will give you warning if you turn it upside down and it leaks water out or whatever. Okay, ladies and gentlemen, if you will stand, I have an oath that I have to give you. And raise your right hand, please. Do you solemnly swear or affirm that you will well and truly try the issues to be joined between the state of Tennessee and the defendant and a true verdict rendered thereto according to the law and evidence to help you God? Thank you. You be seated. Now, before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted, what the attorneys, jurors, and judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you are to go about reaching your decision, but now I simply want to explain how the trial will proceed. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charge is referred to as a presentment. The presentment is a formal accusation charging the defendant with a crime and is not evidence of anything. The defendant has pled not guilty to the charges. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you'll have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, Mr. McMurray for the defense may make an opening statement if he should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. The defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After you have heard all the evidence, I will instruct you about the rules of law that you are to use in reaching your verdict. The final part of the trial occurs when the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand this evidence that was presented. After you hear my instructions and the parties' closing arguments, I will select and excuse the alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence, have his attorney make any statements or arguments, or to produce any evidence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim. It is not a speculation or a suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crimes charged in the presentment. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each witness's testimony. In making up your mind and reaching a verdict, do not base any decisions on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. Keep in mind that you may consider both kinds of evidence, which are considered to be of equal value in the law. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in the hallway or at some other location. If you do, perhaps the best standing rule is not to say anything. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. During the course of the trial, you will receive all the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not engage in any outside reading, visit any places mentioned in the case, or try to learn about the case outside of this courtroom in any other manner. I do not know if there will be any media reports in the newspapers, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decision solely on the evidence you hear in the courtroom. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind and you may not refer to that statement in your later deliberations. You may not ask questions. It is the responsibility of the attorneys to present the evidence. You must decide the case on the evidence presented to you. However, during the course of the trial, I may ask a question or two of a witness. If I do, that does not indicate that I have any opinion about the facts in the case or that I have any opinion with respect to that witness's credibility. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing, and in some instances, I may ask you to retire to the jury room while we discuss matters out of your presence. I will try to avoid as many of these interruptions as possible. I ask your patience because these interruptions are necessary points in the trial where we will have to resolve legal issues. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you. We will now proceed with the reading of the indictment or presentment.
Presentment. Case number S72141, State of Tennessee, County of Sullivan, Criminal Court, charge perjury, count 1. The grand jurors for Sullivan County, Tennessee, being duly sworn and impaneled, upon their oath, present and say that Doug Woods on or about July the 8th, 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully and with the intent to deceive, make a false statement under oath, to wit, that the defendant did personally serve process on Christopher Nile Debtor in Sullivan County General Sessions Court, Civil Action Number 19-RK-45842, contrary to Tennessee Code Annotated Section 3916-702, Class A misdemeanor and against the peace and dignity of the state of Tennessee. Signed, Barry P. Staubus, District Attorney General.
Go ahead and read it all.
Yes, sir. Charge perjury, count 2. The grand jurors for Sullivan County, Tennessee, being duly sworn in and paneled, upon their oath, present and say that Doug Woods, on or about July 18th, 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully and with the intent to deceive, make a false statement under oath, to wit, that the defendant did personally serve process on Christopher Nile Debtor in Sullivan County General Sessions Court, Civil Action Number 19-RK-49844, contrary to Tennessee Code Annotated Section 3916-702, a Class A misdemeanor and against the peace and dignity of the state of Tennessee. Signed, Barry P. Staubus, District Attorney General. A true bill was returned on September the 25th, 2019. Signed, Barbara, can't read her last name, Sanders, foreman of the grand jury.
All right. Mr. McMurray, how does your client plead?
Please not guilty, Your Honor.
Does the state have opening statement?
Yes, Judge.
You may proceed.
Ladies and gentlemen, the proof in this case will be very straightforward. The proof will be that on July the 18th of 2019, the defendant, on a legal sworn document, an affidavit of service, swore and signed his name that he personally served Christopher Nile Debtor in 2 civil cases, process notifying him, Mr. Debtor, of the civil actions against him with the intent to deceive, and that sworn affidavit was false. That will be the state's proof. The state thanks you for your time and your attention to this matter. And at the end of this case, we will return and ask you, because the evidence has proven the defendant guilty beyond a reasonable doubt, to return a verdict of guilty on both counts. Thank you.
Thank you, Jim. Mr. McMurray?
Yes, sir. Good morning. My name is Joseph Ward McMurray, and I represent Mr. Doug Woods. He stands before you innocent of the charges of perjury. Now, there was some questions asked earlier regarding crime shows. I'm sure many of you all have seen some of the movies, the dramas, the shows about, the criminal defense attorney goes out and frees the innocent man. And there's this ideal, there's this concept about the innocent man, how it induces all of this productivity, all of this drive behind the criminal defense attorney. But I'm here to tell you that's not the truth. It incites sheer terror. It haunts me like a demon. The thought of an innocent man being convicted, being found guilty, that is the night sweats. That is the reason I haven't slept for 2 to 3 nights. That gave birth, that concept gave birth to those principles and those concepts that we talked about earlier, that each one of you raised your hands and told me, yes, we'll have the presumption of innocence. Yes, we'll hold the state to beyond a reasonable doubt. That's why they're there. Better that 10 guilty men go free than one innocent man. Because otherwise, the innocent man is served injustice here. How is the state any better than any other criminal that comes through this court? Now, don't get me wrong. Don't get me wrong. I devote my working life to the honor and the respect of the criminal justice process. I do. I'm a former DA. And if Mr. Woods, if I thought that you all would find Mr. Woods guilty, at the end of the day, after the state's proof, wouldn't have any problem with this case. There'd be no loss of sleep. But there is a ghost. It haunts me. And I stand before you today and I submit to you that after you've heard the state's proof, that you will find Mr. Doug Woods not guilty of the 2 counts of perjury. In the state's case, they're going to offer 3 witnesses. One, Isaac Allman. He's an attorney in Kingsport, of good standing with the bar of Sullivan County as well as Kingsport. And he'll testify that there were 2 civil cases that needed to be served. There were aliases that were presented. That is a fancy term, okay? It's a fancy term meaning that this individual was evading service for quite some time. And it's on a civil case. It's on a civil case. And he will also testify. He'll also testify that those errors that were on the summons as well as the affidavit were corrected. And they were corrected weeks before the investigation, a criminal investigation, was started. Now, in addition, I believe this.
I'm sorry.
Yeah.
May we approach?
Yes.
Now, in addition, you will hear from, okay, I believe you will hear from Detective Price, okay, Sergeant Price. He's here today. And it's at that point where
Your Honor, I'm sorry. I apologize.
ladies and gentlemen of the jury, hang tight. We will get to the end, and I'm confident in this process. I appreciate each and every one of you being here today. Okay? And just keep in mind those concepts that we talked about, as well as the concept mistake versus intent. Thank you.
Thank you, Mr. McMurray. Call you first.
Yes, sir. Sir, the state calls Isaac Allman, please. Your Honor, may Mr. McMurray and I approach?
Wait. I forgot.
Yeah, I don't think you were there long enough, but go ahead.
This is just for clarification about exhibits and how the court wants us to handle that.
Ladies and gentlemen, if there's any reason that if you can't hear him, then get my or the officer's attention so we can figure out and make sure that you can. All right. And Mr. Allman, the black one is recording and the silver one is amplification. So if we just use both of them.
Will you state your name, please, for the ladies and gentlemen of the jury?
Isaac Allman.
And what is your occupation, sir?
I'm an attorney.
And where do you currently work, sir?
Wilson Worley Law Firm.
And how long have you been an attorney there?
Almost 4 years.
Okay. And where is your office located?
Kingsport.
And is that a location in Sullivan County?
It is.
Okay. And the primary focus of your practice, is it a civil business focus?
Yes.
Okay. And as part of your employment with Wilson Worley, do you represent creditors when individuals fail to pay loans or debts?
I do.
Okay. And do you do that on a regular basis?
Yes.
And have you done that since you began working with Wilson Worley?
Yes.
Okay. Now, if you could, please, just explain generally the court process that must be complied with when you begin to collect a past due debt.
Generally, a lot of the debts that we collect are smaller debts. We first fill out what's called a civil warrant. Once it's filled out, we take it to the clerk. The clerk issues it. Our courier then returns it back to our office, and then it is assigned to a process server.
Okay, let me stop you there. When you file the civil paperwork, does it set forth the allegations in terms of the person that is the debtor?
It does, and it also sets forth the hearing date.
Okay, and so when that's filed, does the General Sessions Court clerk, do they set an actual appearance hearing date for the parties to come to court?
They do, just on the face of the warrant.
Okay, and so once you get that returned to your office, you're aware of what that hearing date is?
Yes,
Okay. And so you said that once the paperwork is returned, then it is assigned to what you said was a process server?
yes.
Okay, explain that if you could.
We hire process servers to serve process. We don't serve it ourselves.
Okay. And just again, for the ladies and gentlemen of the jury, when you talk about process, is that the legal term for giving the person who is a party to the lawsuit notice that that lawsuit has been filed?
Yes, we serve them with process is what it's generally referred to.
And is that basically giving them a copy of that paperwork you just talked about?
Yes, and putting them on notice that they've been sued.
And also that there's a hearing date for them to appear?
Yes,
Okay. And is that a process that is required by law that you follow?
yes. A defendant has a constitutional due process right to be noticed to a lawsuit.
Okay. And when you talk about a person serving process, are there also legal requirements that must be followed to ensure that you get what's called proper service?
Yes.
And what is that?
Anyone over the age of 18 not a party to the lawsuit.
And does the law also require that a person who's a party to a lawsuit or being sued be given what we call personal service?
Yes, with few exceptions.
Okay. And personal service just means they actually get a copy of the paper in hand,
It means, that's right.
hand to hand.
Delivered. Yes.
Okay. And there are some exceptions to that, but generally that's the process that must be,
Yes.
is required that you follow.
We don't follow it. We don't go into the exceptions unless it's an absolute necessary.
Okay. And again, you've touched on that there are reasons for what are known as the rules of procedure regarding service and a filing of lawsuits.
Yes, our judgment's no good if the process is no good.
Okay. And is it, again, to let the person know that there is, in fact, a lawsuit against them,
Yes, and to notify them of the hearing.
to notify them of the hearing date, and also that they have a right to appear and defend themselves?
Correct.
And does it likewise prevent someone from suing a person without their knowledge and obtaining a judgment against
That's
them?
right, yes.
Okay. So it's, would you say that it is extremely important, and also the law, that process is followed?
Yes,
Okay.
yes.
Is there a specific amount of notice that a debtor must be given before that hearing date?
In general sessions, it's 5 days.
Okay.
They have to take delivery of the process 5 days before the hearing.
Okay. So again, that's the hand-to-hand
That's right,
personal service.
yes.
Okay. And you indicated that your firm hired what you call process servers.
Yes.
What role do constables play in process service?
Generally, that's the people we hire, at least locally, to serve process. Is typically who we hire.
Okay. And do the constables or process servers get paid for serving papers for your firm?
Yes.
Okay. And once the process server gives hand-to-hand delivery of those papers, what do you then, or what happens after that?
Generally, the process server will return the warrant to us with an affidavit. We require them to do an affidavit of service, which is attached to the warrant, and then our courier delivers all of that back to the clerk.
Okay. And an affidavit, you indicated that the process server has to fill out an affidavit. Is an affidavit a legal document?
Yes.
And is that a legal document that the contents are sworn to under oath?
Yes.
And who has the authority within your office to swear someone or to affirm their signature on that legal document?
A notary.
A notary. And do you have notaries in your office that are employees?
Yes.
And in the course of your business, do notaries do that on a regular basis?
Yes.
And then if that process isn't followed, in other words, if a person isn't given hand-to-hand delivery and notice of the lawsuit, can you proceed and go forward on that lawsuit?
No.
And if the process isn't performed correctly, can you proceed on that lawsuit?
If we're aware of a problem, no, we can't.
Okay.
If we proceed and we're not aware of it, our judgment's no good,
Okay.
technically.
So either you can't proceed or if you obtain the judgment not realizing, then the judgment's not a valid judgment.
Correct.
Okay. Now, the affidavit of service that your firm uses, it has a heading on it that identifies it as an affidavit, in fact.
We have affidavits that we use, and then sometimes the constables use their own affidavits.
Okay, but they all say affidavit on them.
I believe so.
Okay. As to your knowledge, they use those.
Yes.
Okay. And then also the affidavits contain the language that the contents are being sworn to and certified to.
Correct.
And again, there's a place for the process server to sign on those affidavits.
Yes.
And does it also contain the specific information as to what was done in terms of the service of process?
Yes, correct.
Okay. And let me then direct you to the lawsuit that was filed against Christopher Detter. Back in 2019, did you represent Eastman Credit Union regarding 2 civil debts not paid by an individual by the name of Christopher Detter?
I did.
Okay. And did you, as a result of that, file 2 civil lawsuits in the General Sessions Court for Sullivan County at Kingsport, Tennessee?
I did.
Okay. And the last one that was filed, or the last 2 that were filed, those were filed on May the 15th of 2019. Is that correct?
I don't recall without looking at the.
Okay.
At this,
I will present to you those documents in a moment, and will you verify that that was the date that they were filed?
Yes.
Okay. And do you recall, without looking, the trial date that was set by the clerk when it was filed?
June 10th, I think.
Okay, if the document reflects July 10th, would that be
Yes.
accurate?
Yes.
Okay. So your memory is July the 10th, 2019.
Yes.
And when I, again, present these documents to you, will you verify that?
Yes.
And we'll go over that again.
Yes.
Okay. Now, did you, once those civil warrants had been filed with the General Sessions Court clerk, did you hire Doug Wood to serve the process? In other words, give Mr. Detter notice of those civil lawsuits?
Yes, the firm hired me.
And what is Doug Wood's occupation, sir?
He's a constable.
Okay. And was he regularly employed by your firm to serve process
Yes.
back in 2019?
Yes, at the time.
Okay. And if you would, just for purposes of identification, do you see Mr. Woods in the courtroom?
Yes, I do.
And could you identify him for the ladies and gentlemen of the jury?
And Judge, we
He's the
would
gentleman
stipulate
in the red shirt.
identification.
Let the record reflect, he's identified.
Thank you. And again, in his capacity as constable, you hired him to serve those papers against Mr. Christopher Detter.
Yes.
Okay. Now, prior to the July the 10th trial date, did Constable Woods notify your office that Mr. Detter had been served with those civil lawsuits on both cases?
He returned an affidavit.
Okay.
I'm not sure if that's the question you're.
Yeah, that's
Yes.
what I'm asking.
Yes.
So, in other words, you were aware that the papers had been served,
Yes.
or at least that was your information.
Yes.
Okay. Do you recall the date on that?
On the affidavits?
Yes.
It was July 3rd, I think.
That Mr.
that they
Detter
were
was.
served.
Okay.
That's what was on the face of the affidavit.
And were there affidavits that Mr. Woods signed, 2 of those, because there were 2 civil lawsuits, that he signed in your office on a date in July?
Yes, it's my
Okay.
understanding he did.
And were those affidavits notarized by a notary public?
Yes,
And that was somebody that worked in your office?
yes.
Okay. And as a result of that, did Mr. Woods submit an invoice to your office for serving the civil process against Mr. Detter?
Yes,
And as a result of him submitting that invoice, was he paid?
yes.
And after obtaining the sworn affidavits on both civil lawsuits, did you or did someone in your office file those as proof that Mr. Detter had in fact been given personal service?
Yes, they were filed with the clerk.
Okay. Now, let me take you to the date, the July 10th date of 2019. Did you personally appear before Judge Ray Conkin?
I did.
And Judge Conkin is a General Sessions Court judge in Kingsport, Tennessee.
He is.
And on that day, was the purpose of your appearance to appear on behalf of your client, Eastman Credit Union, against Mr. Detter for those 2 civil lawsuits?
Yes, and to obtain judgment.
Okay. And once you arrived, was Mr. Detter present?
He was.
And did you speak with him concerning the lawsuits?
I did.
Now, he wasn't represented by an attorney.
No.
So you were able to speak with him personally.
Yes.
And without saying what he said, but based upon your conversation with Mr. Detter, did you have concerns about the sworn affidavit signed by Constable Woods and that you had filed with the General Sessions Court clerk?
Yes, I did.
And did you have concerns that what was contained in those sworn affidavits was not true,
Yes.
that the information was false?
Yes.
And as a result of the conversation with Mr. Detter, did you then go back inside the courtroom and request Judge Conklin to reset the lawsuits against Mr. Detter so that you could further look into the situation?
I did.
So it was enough that you did not feel comfortable proceeding with those lawsuits that day?
That's correct.
Okay. Now, subsequent to that, in other words, after that, did you or other members of your firm with you present meet with Constable Woods at your office?
Yes.
And do you recall the meeting date?
July 17th.
Okay. And was that again at your office there in Kingsport, Tennessee?
Yes.
And tell the ladies and gentlemen of the jury what your conversation was, sir.
Basically, Mr. Woods acknowledged that he had not personally served the process on Mr. Detter and acknowledged that he had signed the affidavits, which was what only thing we were concerned with.
Okay. And did he give you any indication did he make any statements to you about that service or anything like that?
Other than that he didn't serve them.
Did you have a conversation with him about whether or not that was the appropriate thing to do or not? What did he say about that?
I think he did acknowledge remorse. I don't recall.
Okay. Did you have any conversation with him where he acknowledged what he did was wrong and that he should not have done that?
Yes, I
Judge,
believe he did.
I'd object. I mean, I think at this point it's legal. If we can approach.
No, sustained. It was leaving.
And again, do you recall what he said?
Yes, he told us that he did not sign it, and he was sorry, and that he wouldn't let it happen again.
Okay. And as part of, I guess, your firm continuing to look into this, did you discover that someone else had served Mr. Detter?
Yes, he did tell us that Rhonda Willis, I believe, or Rhonda Wills had served him. He did tell us that, and we did ask him if she would sign an affidavit.
Okay. And let me, I guess, back you up just a second. Did you know Rhonda Wills?
I don't think I did.
Okay. She was not an employee of your
No.
firm, and,
No.
and you had not hired her
No.
to do this service.
No.
And so after speaking with Doug Woods, did you speak with her?
I did not personally, that
Okay.
I recall.
Did you learn that she had in fact served that process?
He told us she did.
Okay. So based on what he told you that she had served the process.
Yes,
Okay.
yes, and we requested she sign an affidavit.
And that's going to be my next question.
Yes.
As a result of that, did you ask that she come in
Yes,
and fill out a sworn affidavit that she in fact served that process?
yes.
Okay. And as a result of her signing that affidavit, what did you do with regard to the affidavits, the sworn affidavits filed by Mr. Woods?
We attached the affidavit signed by Rhonda Wills to a letter that asked the clerk to withdraw and disaffirm the affidavits filed by Doug Woods, and to file the new affidavits signed by Rhonda Wills.
And what was the purpose of disaffirming and withdrawing that sworn affidavit filed by your office regarding Doug Woods?
The rules of professional conduct require us to withdraw and disaffirm any document we come to know is false, if we come to know that before the conclusion of a case.
And so did you in fact do that?
Yes.
Okay. And let me then, if I may, there were two case numbers, and they're very similar.
Yes.
But just for clarification, one ends with 45842 and one ends with 45844.
Yes.
Okay.
I believe so.
Okay, I'm going to show you these documents. I'm not trying to confuse you. Just for the record and for clarification. Let me show you first the paperwork regarding 45842. And just for the records, there are 3 pieces of paper that I'm going to hand to you.
The first is what appears to be a certified copy of Civil Action 19-VK-45842. It was issued May 15th, 2019. It was set for July 10th, 2019 at 9:30.
Okay. And does it identify this as being a civil lawsuit filed by you against Christopher Nall, debtor?
Yes.
Okay. And just for clarification, at the top of that document, there's typed the word alias.
Yes.
What does that mean?
When these are issued, they're only good for 60 days. So if it takes us longer than 60 days to serve it and return it, what we do is go back. We use the same warrant, but we put alias at the top of it, and the clerk reissues it.
Okay. And so that word at the top simply designates that this is a second attempt to give notice of the same lawsuit that you had previously filed.
Yes.
So that's what that means.
Yes.
Okay. Now, let me direct you to the next page just so we can get this introduced. The next page, can you identify that document?
Yes, it's an affidavit of service. It identifies the same case number 45842. It says type of service, personal service by hand. Received this process on Christopher Debtor. It says served, time 2:00 p.m., date July 3rd, 2019. Address where served, it looks like that's 45 or 4309 Fort Henry Drive. Work, Rafi Els. It's signed Constable Doug Woods, date July 8, 2019.
Okay.
And it's notarized by Patricia Arson.
Okay. And then the third piece of paper appears to be a letter on your firm's letterhead signed by yourself dated July the 26th, 2019.
Yes.
Okay. Your Honor, the state would move for that to be state's collective exhibit 1.
No objection, Your Honor.
All right. And what was the last,
It was a letter.
no,
I'm sorry.
the last numbers of the case number?
Oh, 842, 45842. Your Honor, I'm going to ask that this exhibit be published to the jurors and then ask that the marked exhibit be given back to Mr. Allman for purposes of testimony.
I don't tell them that. Do we need to staple those 3 pages together?
I've got them paper clipped. I don't know if that.
Because if she hands him something else, I don't want to give him.
Thank you.
Ladies and gentlemen, the way we're going to handle exhibits is different than what we've ever done before. We've got the original up here that's marked. It will come back with you when you deliberate. But for now, in order to publish these documents, we're giving each of you a copy that you can put in your notebook, and you'll just keep that copy throughout the course of the trial. And at the end of the trial, when I go over jury instructions, I'm going to hand you a copy of the jury instructions as well that you can put in there so you can follow along. That way we don't have to hand paper from one person to another through the jury.
Judge, I did notice, I think the hole punches on the second and third pages are upside down. I'm sorry. I just saw that as I was handing those out.
2 demerits.
I know. Just get the exhibit back. You want one?
Yeah.
Mr. Almond, do you have exhibit 1 back?
I do.
Okay. Now, I'm going to have you look at page 1 of exhibit 1.
Yes.
You have identified that this is the civil lawsuit, and now that the jurors have a copy of the exhibit, the alias is at the top of the document center.
Yes.
Okay, and of course you've explained that. It identifies who the plaintiff, that would be Eastman Credit Union, and then the person who's being sued is Mr. Debtor, correct?
Yes.
Okay. And then on the right-hand side, middle of the way down, there's a couple of dates.
Yes.
Are those the dates that you refer to as the dates that the clerk issued it, and then the date the clerk set it for trial?
Yes.
And those dates are?
It was issued May 15th, 2019. It was set for trial July 10th, 2019 at 9:30.
Okay. And then right below that, there's a box of sorts that has service.
Yes, it says served upon all named defendants, and then it appears that Doug Woods signed it at the bottom of that box, dated 7/3/2019.
Okay. All right. Thank you. Now, the next page, which will be page 2 of Exhibit 1, is that the affidavit of service that you've testified about, sir?
Yes.
And again, that's something that's required by your office in order to comply with the rules of civil procedure.
Yes.
Okay. And what is the date that is dated?
It was sworn to and subscribed before me this day of July 8th, 2019.
And that is, it was notarized because it's a sworn document by your employee?
Yes, Patricia Hartsock.
Okay. And it is signed by who, sir?
It appears Doug Woods.
Okay. Now, page 3 of Exhibit 1, that is the letter from your firm that you testified about.
Yes.
And that was on, what date was that
July
sent?
26, 2019.
Okay. All right. Thank you. That's all with Exhibit 1. Your Honor, if I may have the next item shown to Mr. Almond. Mr. Almond, do you recognize there are 3 pages contained within the item that was submitted to you? Do you recognize all 3 of those?
Yes.
Okay, page 1, is that the civil warrant that was filed in case ending in 45844?
It was.
So that's the second lawsuit filed against Mr. Debtor.
Yes.
And is this the same document that you testified to regarding Exhibit 1, the same paperwork that was filed by your firm?
Yes, just the second lawsuit.
Okay, and this one likewise has the term alias at the top.
It does.
And that just references that there were additional, the original was filed and you were not able to obtain service, and so you reissued it. Is that correct?
That's correct.
Okay. Let me move you to the second, page 2.
Yes,
Is that the second affidavit of service that
yes,
you referenced?
yes.
And whose signature is on that document?
Appears to be Douglas.
Okay. And the third page is a letter from your firm,
Yes,
similar in nature to the letter that you've already testified about in the previous lawsuit.
yes, correct.
Your Honor, state would move to introduce that as collective exhibit 2 for the state.
Any objection?
No objection, Your Honor.
Be collected to full exhibit.
Your Honor, if I may have that exhibit published to the jury, please.
You may.
Should be. I was gonna give it to you.
Thank you.
Sure, I would note that in this particular, on page 1, where the hole punch is, alias,
It's fine.
okay, it's cut off. But it's there. Mr. Almond, do you have the exhibit back? Yeah. And now that the jurors have collective exhibit 2, let me direct you to page 1 of that exhibit. Does it again identify the parties to the lawsuit, same as the previous exhibit?
Yes,
And it's the same document, except that it has a different case number indicating it is a second lawsuit. Is that correct?
yes. It's a different day.
And does it likewise reflect that it was issued and set for the dates that you previously testified to?
It does.
And underneath that, does it indicate service of process?
Yes.
And how does it indicate that was completed?
All named defendants, served upon all named defendants served 7/3/2019. Douglas.
The page 2 of exhibit 2, is that the affidavit of service in this particular lawsuit that you testified about?
Yes,
And does it likewise verify under oath the contents of that affidavit?
Judge,
And-
I would object to likewise. Likewise, the first document is not signed under it. First page of the document.
Are you talking about page 1 of exhibit 2?
Yes, ma'am.
I'm sorry, that, I will correct that, Judge.
All right.
That was my error.
Sustain.
When I said likewise, I apologize, Mr. Almond. I didn't mean to be confusing. When I said likewise, there are 2 affidavits that were sworn to by Mr. Woods. Is that correct?
yes, he signed the first page, the actual warrants, and then the second one is also signed.
And are there 2 affidavits of service? Both of them are page 2 of exhibits 1 and 2.
Yes,
And with regard to the exhibit that you have right now, which is exhibit 2, if you're looking at page 2, does it appear to be similar in nature to page 2 of exhibit 1?
yes,
Is it also an affidavit of service?
yes,
And does it likewise a document that's sworn to under oath?
yes.
And whose signature is on that exhibit?
Appears to be Douglas.
And what was the date that is indicated it was signed?
7/8/2009.
Okay, thank you, sir. And then with regard to page 3 of exhibit 2, is that a
Yes,
letter
that is
from, I'm
that
sorry,
That is a letter that came from our office.
Okay, and is that, you testified that you withdrew and disaffirmed the original affidavit, which would be page 2 of
Correct.
Exhibit 2?
Yes.
And is that, what you did with regard to that affidavit? Okay, all right, thank you, sir. Trish, do you have a copy of that? Your Honor, if I may have, this item shown to Mr. Almond, please. Mr. Almond, do you recognize, what's been handed to you?
Yes,
What is that, sir?
it is a statement for $80 for civil service. Your affidavit.
And is that, an invoice that was submitted by, the defendant Doug Woods to your office for payment?
Yes.
Your Honor, I move that to be take exhibit number 3, please.
Judge, no objection.
And ask that it be published to the jury, please.
Okay.
And Mr. Almond, if you could look at that now that the ladies and gentlemen of the jury have exhibit 3, does it simply indicate the case numbers, and then reflect the amount requested for payment?
Yes, it also has our file number.
Okay, and does it indicate that your firm did in fact make that payment to Doug Woods?
Yes, they paid me $80.
And that was for, in the course of his employment for service of process on those lawsuits?
Yes.
Okay, thank you. Chairman, I have just one moment.
Yes.
That's all the questions I have, and I'll.
All right. You may cross, Mr. McMurray.
Judge, good morning, Mr. Allen.
Morning.
How are you?
Well, and you?
Not too bad. Did you ever think, going to law school, that you'd be sitting here today in a criminal?
No.
Now, Mr. Allen, there's a couple of questions that I'd like to ask. Okay. First, could you describe to the jury approximately how many cases of these? I guess I could call them debtors cases. Is that accurate?
Yeah, I think so.
Yeah, the civil suits, small civil suits on sometimes credit cards and small loans. Correct.
Mhm.
Approximately how many cases have you done? I think you said 4 years of experience, Wilson Road. How many would you say that you've done?
I don't know. It's not something I track.
Sure. Would you say that was over 50?
Yes,
Would you say it was over 100?
probably.
Okay.
I don't know.
It's fair to say quite a few.
Yes.
I can take this off. Okay. Have, in your experience, is this the first time that there has been an affidavit or a summons that's had an error on it?
Your Honor, I would object to the clarification, to the characterization of it being an error. That's the ultimate question for the
That's the
jury.
question for the jury.
Sure.
Yeah.
And he described it as I believe he said it was false. And that would be an ultimate question for the jury. So I do believe we need to maybe define what word we can use. And I believe false has the same connotations.
Your Honor,
Exhibit 1, please. State's Exhibit 1.
All right, that was muted, so let me just say, the objection was overruled in part, sustained in part, and McMurray can proceed.
And Judge, if I could step away and just grab mine.
Get your mask. Don't forget your mask.
Okay. Now, Mr. Allman, correct me if I'm wrong, but the State's Exhibit 1, is that 19 VK 45842?
Yes,
Okay. And are you looking at the same document here? Basically, it's just what I would call a summons. I think you actually classified it as a warrant. Is that right?
yeah, civil warrant.
Civil warrant. Thank you. Thank you, Mr. Allman. If we can look at the right-hand column there, I'd like to go down, I think we could say 3 sections.
Yes,
You see that?
yes,
It says served upon, and then there's a box check.
yes.
Okay, it looks like there's a date on mine. It's a little faint. Is there a date or a time on yours?
I'm not sure.
Okay, well, that's fine. That's fine. And then if we go on down, it says served
Yes,
7-3, right?
yes,
2019.
yes,
Below that is a little circle. It says constable.
yes.
Then it has a name.
Uh-huh,
That says Doug Woods, right?
correct.
Is that signed under oath?
It is not.
It is not. But let's turn to the second page. I believe that's the affidavit of service. Is that correct?
Yes,
Okay. Well, let's go on down to that section that is in all caps. Okay? Do you see
Yes.
that? It says, I certify that I am not a party to the above action or suit. Correct?
yes,
And that I'm over the age of 18 years, right?
yes,
And the above affidavit is true and correct, right?
yes.
Then it is signed by whom?
Constable Doug Woods,
And that is notarized, right?
correct.
So that first part, I certify that I'm not a party to the above action or suit. Is that true or false to the best of your recollection, or to the best of your ability?
True,
And that Mr. Woods is over the age of 18 years. Is that true or false?
I assume he's over there.
Yeah, that's a good assumption. Thank you. And the above affidavit is true and correct. That's the last thing that he swears to, right?
Yes,
Okay. So let's go through it. Line by line. Plaintiff, Eastman credit. Is that true?
yes,
Okay. Defendant, Christopher Nile debtor. Is that true? Okay. Defendant to be served, civil summons. I believe you classified it as a civil warrant, right?
yes.
But you're not saying that, you didn't have issue with that part, right?
No,
Okay. All right. Case number is 19-VK-45842. Is that correct?
correct.
Okay. Well, let's skip over that next one. We'll go back to it. I promise we'll go back. Receive this for process on Christopher Nile debtor. Is that correct?
I'm not the one that filled out the affidavit, nor am I the one that signed it.
Oh, I know. I'm not saying that,
Yeah.
but
I can attest to it,
yeah.
so go ahead.
Okay. But to the best of your recollection, or to the best of your ability, that is correct, that Mr. Woods received that for process on that named individual, right?
Yes,
Okay. And address where served or attempted to serve. And that's 4309 Port Henry Drive, or work is Raphael's. Do you have any information which would lead you to believe that that is false?
I do not.
Okay. So let's go back to that type of service. Personal service by hand. How was Mr. Debtor served?
As far as I know, personal service by hand.
Okay. So that statement is not false.
No.
Okay. Thank you.
As far as my knowledge.
As far as your knowledge, right. But correct me if I'm wrong, you submitted another affidavit, is that correct? Oh, with Rhonda Wills.
Yes,
Okay, right. When she swore that she served it by hand, personal service.
Yes,
Okay,
best of my recollection.
best of your recollection. All right. Now, I'd like to go to State's Exhibit 2, if we can. The witness can. Now, again, same line of question. As far as the summons or the civil warrant, however you want to classify it, there is no oath that was given on that document, right?
No,
Right. And just for clarification, we're talking about 19-VK-45844, right?
yes,
Okay. All right. Now, I would like for you to take a look at that affidavit of service assigned to this next case, which is VK45844.
yes.
Okay. Same type of question, but I'm not going to belabor you with it, Mr. Allman. Is there anything on that affidavit that you can tell this court and this jury is false?
My personal knowledge is that Mr. Woods did not serve it.
Well, my copy does not say that Mr. Woods served it. Does your copy reflect that?
Well, he certifies that he's not a named party to the action and that he's over 18.
Right.
Yes, and the rule requires the person to serve it to sign, and we require them to file an affidavit.
Is that rule in this affidavit of service?
No, it
Okay.
is not.
So this statement, not what the rule says, but what Doug Woods said. What Doug Woods said. On this statement, has Doug Woods said that he personally served it? Yes or no?
I think yes.
Could you
You're trying
explain
to
that?
split a hair that ain't there.
Well, explain that to me. Did
He's written by practice of the court, by me submitting this affidavit,
Sure.
and as an officer of the court,
Mhm.
I am telling the court that Doug Woods has given me an affidavit and that he's sworn to me that he has served it
But-
by hand delivery.
But Mr. Allman, that is what you are telling the court. We're here today on what Mr. Woods has said and what Mr. Woods has sworn to. This is a criminal action.
Your Honor, I would object. I think we're crossing into the line of argumentative with the witness. Certainly, the state would not object to the defense asking questions.
Right.
And the document
Just to the fact
speaks
that
for
it's
itself.
argumentative, I'm going to
Okay,
sustain it.
well, all right, let's go through this. The first line, plaintiff, Eastman Credit, is that correct?
Yes,
Okay. Defendant, Christopher Nile Debtor, is that correct?
yes,
Okay. Defendant to be served, civil summons, is that correct?
yes,
Case number 19-VK-45844, is that correct?
yes.
Okay. Type of service, personal service by hand, is that correct?
To my knowledge, it is.
Okay.
I wasn't there.
Sure, thank you. Received this for process on Christopher Nile Debtor, is that correct?
Yes,
Okay. And as far as the date and time, and again, you weren't personally there, but do you have any information that you could tell the jury that is false?
yes, Mr. Woods told us it was false,
That the date and time is false?
that he did not serve it.
Does it say that he served it?
It says served,
It says served, but does it say by whom?
yes, by Constable Doug Woods.
Where does it say that?
It says, I certify that I am not a party to the above action or suit, and that I am over the age of 18 years of age. And the above affidavit is true and correct.
Okay. But where in what you just read said that Constable Doug Woods has served the
Your Honor,
the
again,
So
Yeah,
Mr.
that-
McMurray,
State
Sustained.
objects, just take this, Your Honor. The state objects for the same reason.
It's argumentative.
Exactly.
But Judge, I'm asking him where he's getting that statement.
You're
that he
arguing.
testified.
You're arguing. That's
With the
you've
witness,
asked him
he's
if it's
arguing
true or
with the
false,
witness
and
about what the document says, and it's an exhibit.
so I sustain that objection.
Okay. So to the best of your recollection, or do you have any information that you could tell this court or the jury that Mr. Christopher Nile Debtor was not served on July 3rd, 2019 at 2 p.m.?
I do not.
Okay, all right. To the best of your recollection, or God, I keep saying that, to the best of your ability, do you have any information that would, or to your knowledge, that Mr. Doug Woods, my client, attempted service at 4809 Fort Henry Drive, or Raphael's?
Your Honor, I would object. Mr. Almond would not have, it asked the
Well,
witness to
that's-
speculate. He wouldn't have any personal.
Well, he asked him to his knowledge, so
Yeah,
if he
that's
knows
fine.
it, he can answer it, and if he doesn't know it, he can say he doesn't know it.
Go ahead, ask your question.
Okay. Do you have any information that Mr. Woods did not attempt service on 4809 Fort Henry Drive or Raphael's?
That he did not.
That he did
attempt
not.
service?
That is
I
false.
do not have.
Okay.
And as far as I'm concerned, I don't care how many attempts he has, as long as they serve him.
Right. That's really what you're after, correct?
Correct.
And regarding that fact, there was an alias that was issued, right?
Correct.
Okay. Do you know how many times an alias was issued in this?
I do not recall.
Okay. Did you ever keep notes, records regarding the attempts that Mr. Woods had made on service process on this individual?
I'm not going to speculate on that. No,
Right.
I don't recall.
You don't have
And as
any,
far as you asking for things that are in the client file, I can't
Sure.
disclose that.
but you don't have any information regarding how many attempts Mr. Woods has made on serving Mr. Debtor?
Your question is, what was your question?
My question is, do you have any information regarding the number of attempts that Mr. Woods has made on serving Mr. Christopher Debtor?
I don't have any recollection.
Okay, that's fair enough. Now, you were interviewed by the Sullivan County Sheriff's Office, correct?
I was.
Okay. Do you recall when that interview took place?
I do not.
Okay. Do you recall some of the statements that you made during that interview?
I do not.
Okay. Do you recall making the statement to Mr. Price, or Detective Price, I'm sorry, that you don't know what you would have done had Doug gave you a contradictory statement?
That's correct.
Okay.
And the reason is the rule requires us to withdraw it and disaffirm it if we know. We wouldn't have known if.
Right. So it's basically Christopher Nile Debtor's word against Doug Woods, right?
No, Doug told us that he didn't personally serve it.
Right, but before that, before you talk to Mr. Woods, it's basically Christopher Nile Debtor and Doug Woods, right?
Correct.
Okay.
I think I understand your question. I'm not sure. So go ahead.
Well, let's make sure that we're clear. Basically, what I'm saying is that you had information from Doug Woods, Exhibit 1 and 2, right?
Yes.
Which led you to believe a certain thing. And then Mr. Christopher Nile Debtor told you something different, correct?
Correct.
Okay. All right. So basically, your statement to Detective Price was, if Doug would have said, no, I served it, you don't know what you would have done.
That's correct.
Yeah. If Doug had worked for you, or I'm sorry, Mr. Woods had worked for you for how long?
I don't know.
Years? You think?
Several years at least, yes.
Okay. All right. Never had a problem before?
Your Honor, I object. It's not
Sustained.
relevant.
Sustained.
Okay. At one point during that interview with Detective Price, you described Mr. Woods' statement or his behavior as very forthcoming. Do you recall that?
Yes.
All right. Do you still believe that he was very forthcoming
Your
that
Honor,
day?
again, I object to the relevance of this line of questioning.
How is that not relevant? It's going back to,
Come up here.
I'm sorry.
Objection sustained.
So, Mr. Allman, and correct me if I'm wrong, you called Mr. Woods after that July 10th hearing to ascertain what was wrong with these affidavits, if anything, correct?
Yes.
Okay. And do you recall what date he actually came into your office?
I believe I recall July 17th.
Okay, okay. And it was during that conversation where he actually told you, yes, yeah, I did not serve that, right?
That's correct.
Did he ever apologize?
He did.
Okay. And did he ever take any steps to try to correct that?
We requested Rhonda Wills, I believe, to come in and sign an affidavit.
Okay. Could you tell the jury how many times Rhonda Wills actually came in to Wilson Worley and signed an affidavit?
I have no idea.
If you would, please look at...
At least twice.
Oh, thank you, thank you. Because if you would, please look at State's Exhibit 1. In that last page, that third page. And it reads, and correct me if I'm wrong, that Rhonda Wills signed an affidavit on July 25th, 2019.
Yes.
Okay. Now, if I could have you look to State's Exhibit number 2. According to your letter, that reads that Rhonda Wills signed an affidavit on July 23rd, 2019.
Yes.
Okay. And again, this is in regards to Christopher Naldetter.
Hold on.
Oh, I'm sorry.
Is that working?
That's better. Thank you. Go ahead.
This is in regards to Christopher Naldetter, correct?
Yes. Both these are.
Right, right. And you're representing Eastman Credit Union.
Yes.
And Mr. Detter had promised to pay Eastman a certain amount.
I'm not going there. I consider that attorney-client privilege.
I understand. If you could, please just turn to State's Exhibit number 1. That very top page. Alias, civil summons or civil warrant.
Yes.
Okay. In the top left-hand section.
Yes.
Okay. Your client is Eastman Credit Union.
Yes.
Okay. And correct me if I'm wrong, but as of the date that you filed this, you signed your name at the bottom. You believe that Christopher Naldetter owed Eastman Credit Union $3,809.91.
Yes.
Okay. All right. Now, accompanying this civil summons, did you file any other affidavits from?
Yes.
Okay. And that would be from your client, correct?
Yes.
And when I say your client, ECU
Yes.
or Eastman Credit, right?
Yes.
And in addition to the affidavit, did you file any loan agreements?
Likely. Yes.
Okay. All right. If I could, please have you take a look at
Judge, may we approach?
Objection is sustained.
Mr. Allman, I would like for you to take a look at some exhibits that I have, okay? Look this. I've got a whole bunch.
I'm here first.
Mr. Allman, excuse me, just a few more questions.
Go ahead.
Did you or anyone from your office call the police regarding this matter?
Not that I'm aware of.
How much time passed between, July 23rd, 25th, and when you were interviewed by Detective Price?
I do not recall.
Do you recall, like maybe a couple of weeks?
I can't remember, no. No, I'm sorry, I can't remember.
Oh, that's all right. That's all right. Do you know the result of this lawsuit we're talking about?
Just for clarification, you mean the one against Mr. Doe?
Yes, the two again. Yeah.
I don't, I think we just object for relevance.
Overrule, if he knows.
Do you know?
It was dismissed.
Okay. Right. Did you ever speak to Mr. Detter? Did you ever talk to Mr. Detter other than that July 10th, 2020 conversation?
I may have, but I don't remember.
And if I could have 1 moment, Judge.
Okay.
And Judge, I would pass the witness.
Can you redirect?
Just very quickly, Your Honor. Your Honor, state has no redirect.
All right. Is he free to go?
Judge, what I've asked Mr. Allman, I'd ask the court to allow him to be released to return to his office. He's provided my office with contact information, and should we need him later this afternoon, he's agreed to come back if that's okay with the defendant.
Mr. McMurray, is that okay with you?
Judge, that's fine. I didn't see any need to call him again.
All right. Thank you, Mr. Allman.
Thank you, Mr. Allman.
Their lunch is not here yet, as far as I know. How long do you think the next witness will take?
Well, I would anticipate her being fairly quick.
Let's
I
go
don't
ahead.
want to say she's going to be quick. I think she'll be quick.
We'll at least get started, and then if their lunch comes, we'll stop, and then if we have to, we'll back up, and you can.
And start again. Judge, state we call Patricia Hartsock.
We'll have to wait till Lieutenant Wetzel comes back. Patricia Hartsock.
May I go to the podium?
Yes, ma'am. Ma'am, if you'll raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth? All right. Have a seat there and watch that chariot rolls.
Your Honor, may Ms. Hartsock remove her mask?
Yes.
Good morning, or almost afternoon. You state your name, please, for the jury.
Patricia Hartsock,
Okay, Ms. Hartsock, where are you employed, ma'am?
Wilson Worley Attorneys at Law.
Okay, and is that in Kingsport, Tennessee?
Yes, ma'am.
And what do you do there?
I'm a runner.
And how long have you worked there?
I think about 27 years, maybe longer than that.
Okay, long time.
Yeah, long time.
Okay, and as part of your employment with Wilson Worley, did you become what's called a notary public?
Yes, ma'am.
Okay, can you explain just generally what that is to the ladies and gentlemen of the jury?
You know, the person signs their name, and you have to know them, and they're like they.
Let me ask you a couple questions, okay? Is there a process that an application that you have to make with the state of Tennessee to become a notary?
Yes, ma'am.
And after you complete that process and the state of Tennessee approves you, then do you obtain what's called a seal that authorizes you as a notary to certify certain legal documents, either perform it under oath or affirm their signature under oath?
Yes, ma'am.
Okay, so that's what a notary does.
Right.
And is it fairly common for a law firm like Wilson Worley to have notaries on staff because of the course of their business is that they deal in legal documents that require sworn signatures on legal documents?
Yes, ma'am.
Okay, and is that what you did whenever it was to become a notary?
Yes, ma'am.
And you did that because of your employment with Wilson Worley? Okay, all right. And some of the legal documents, would those pertain to business type, contract type things, but also sworn affidavits? Okay. And do you do that in the regular course of your employment with Wilson Worley?
Yes.
Ms. Hartsock, okay. Now, you indicated that you've been at Wilson Worley for you indicated that you've been employed with Wilson Worley for quite some time. You were working there then on July the 8th of 2019. Okay. And prior to that day, did you know Doug Woods?
Yes.
And did you know him in the course of him serving legal documents and papers for the attorneys there at your office?
Yes.
And was it common practice back in July of 2019 that after Mr. Woods or whoever the process server was, that they would sign an affidavit of service? In other words, swearing that they had obtained service on the individual who received the papers.
Yes.
And then you would notarize that document, that affidavit. Is that correct?
Yes.
Okay. And so had you done that prior to July the 8th of 2019, specifically regarding Mr. Woods and his serving of papers for the company? Okay,
Yes.
you had done that.
Yes.
Okay, so did you know his signature?
Yes.
You're familiar with it?
Yes.
Okay. Now, on July the 8th, did Mr. Woods appear at the office regarding service of process for an individual by the name of Christopher Detter? So it wouldn't be normal for you to remember the names of individuals that the company had to get service of process on because of a lawsuit. But would it be common for you to follow? Do you have a practice that you follow each and every time whenever you obtain a signature of Mr. Woods on an affidavit of service?
Okay, I would either see him sign it or I'd read that your signature.
So you would either personally observe him sign it under oath or you would affirm his signature under oath?
Yeah.
Okay. And because you don't recall, if I may, have you look at what's been identified or marked as State's Exhibit number 1, and I'm going to direct your attention to page 2 of the document you're holding. And at the top of that, is that an affidavit of service?
It is.
Okay. And do you see at the bottom Do you see your signature as the notary?
I do.
And what date does that indicate it was signed in front of you?
July the 8th, 2019.
And the contents of that affidavit, according to the affidavit, was affirmed by who? In other words, who signed the document?
Constable Douglas.
Okay, and so on that day, would you have followed your typical practice of either observing him sign or affirming his signature?
Yes.
And do you in fact recognize that signature?
Yes.
And whose signature is that?
That's it.
Okay. And if I may, have you shown a second document, Ms. Hartsock, that's been previously introduced as State's Collective Exhibit Number 2, and I believe your attention has been directed to page 2 of that specific exhibit. And is that another affidavit of service?
Yes.
Okay. So there's 2 of them there.
Yes, there's 2 case numbers.
Right. So one reflects one case number and the second one reflects a different case number.
Yes.
And again, the contents of that affidavit were sworn to and signed by who?
Constable Douglas.
And do you recognize that signature, Ms. Hartsock?
Yes.
And whose signature is that?
That's it.
Okay. And what date was that signed or affirmed in front of you?
July the 8th.
And
19.
I'm sorry, I cut you off.
July the 8th, 19.
2019? Okay. And does that also have your signature and your notary seal?
Yes.
Okay. All right. Thank you. That's all the questions I have.
All right, thank
Thank you for your testimony, Ms. Hartsock. I don't have any questions.
you. Okay.
You need-
Judge, may
Is she free to go?
Yes, and just out of an abundance of caution, she's going back to work, and if we would need her, we could call her, so she'll be on, I guess, standby, but I don't anticipate that we will.
Are you okay with that, Mr. McMurray?
Oh, that's
You're going to Rogersville? That's fine. That's
Judge,
fine.
I don't
Thank you.
anticipate.
Yes, ma'am. Thank you, Ms. Hartsock.
Put your mask. Lunch here. I need to wait till he comes back to see if their lunch is here.
Okay, now we affirm.
All right, we'll break for lunch at this point. We'll be back at 1 o'clock and resume the trial.
I've tried.
I'm sorry, Judge, I didn't hear you.
Yeah. Okay. It's 1:06 PM. We're back from lunch. The jury has been taken and split equally between the two jury rooms back here for just a moment. The state have another witness.
No, state rest, Your Honor.
Defense have them. Are we on?
Judge, I
Defense
make
have a motion.
motion for a judgment of acquittal.
Okay.
Brief argument?
Oh, go ahead. Yeah.
Yeah.
You stopped talking, so I thought it was time for me to go.
And can I remove this?
Go ahead. Why, just stay right there.
Okay.
We're all having a hard time hearing each other.
Okay. Judge, as to count one, the perjury, just taking a look at the indictment, it lays out that Doug Woods, on or about July 8, 2019, did, with the intent to deceive, make a false statement under oath that he did personally serve process, that the defendant did personally serve process on Christopher Nile Debtor in General Sessions Court Civil Action Number 19-RK-45842. And Judge, if you look at, I believe that would be State's Exhibit Number 1. The only sworn document, the only document made under oath is the affidavit of service. And as the state's witness just acknowledged, every line in this affidavit is true and correct. There's nothing on its face that is false. Mr. Debtor was personally served. There's not a false statement that was made under oath. Now, I know Mr. Allman did take issue when I asked him regarding the other case, RK 49844, with that affidavit. The judge, if you look, those affidavits are the same. They're exactly the same. And so there was no statement made by Mr. Woods that he personally served the process. It's only that it was hand delivered. And so for that reason, I believe Mr. Woods' cases should be dismissed.
Your Honor, of course, the court has the exhibit, and the exhibits speak for themselves. You also have the testimony of Mr. Allman that the defendant was hired by his firm to personally serve process. He testified extensively about the importance of the rules of civil procedure and how things must be served. And based upon that, I mean, certainly the affidavit was signed by Mr. Woods, and it clearly, I don't think there's any question, at least at this point, based upon Mr. Allman's testimony, that Mr. Woods acknowledged to him that he did not, in fact, serve that affidavit, or I'm sorry, serve that process accordingly as he was expected to, and the affidavit reflects that.
All right. Well, as both parties know, in a Rule 29 motion for judgment of acquittal, the court has to view the evidence that I've heard in a light most favorable to the state. And when I do that, Mr. Woods, according to the face of the affidavit, swore that the facts were true and correct, and during the cross-examination, Mr. Allman agreed with Mr. McMurray that all the lines were true, except that the one line that was never really talked about and not agreed to was where it's checked boxes, checks served. And the testimony of Mr. Allman was that Mr. Woods did admit to not serving Mr. Debtor himself. So if I take those facts in a light most favorable to the state, as I'm required to do, I think it's at least a jury question. So I'm going to deny the motion for judgment of acquittal at this time. based on those facts, and it'll go to the jury. Mr. McMurray, will you have proof on behalf of Mr. Woods?
I will, Your Honor.
All right, is Mr. Woods going to testify?
He is, Your Honor.
Okay. And are you ready to go forward right now?
We are, might I have just 5 minutes just to?
Sure.
Yeah.
What I'm going to do is we'll take a short break. That way we can all leave the courtroom. Y'all can go talk where you need to in private, and that'll give the officers time to put the jury back in here without there having to be any close contact by any of us.
Just we'll go out this door and go down here.
Okay.
So when you're ready.
Stay
we'll-
close because it probably won't.
Yeah, we're not even going upstairs. We'll just.
So
go
we're
in
going to
the
take a
hallway.
short break, and then we'll come right back and get
But I
the
don't
All right. General, call your next witness.
Your Honor, the state rep.
Mr. McMurray, does the defense have any proof?
We do, Your Honor.
All right, call your first witness.
Doug Woods.
Mr. Woods, if you'll stand and raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
All right, if you'll have a seat right up here, and if you'll watch your step and watch that chair because it'll roll on you.
Mr. Woods, if you could, tell the jury your full name.
Douglas Wayne Woods.
Now, Mr. Woods, how are you employed?
I am actually retired and I'm a county commissioner.
You're retired?
Yes,
Okay. Are you also a constable?
yes, and a constable.
You're a constable and a county commissioner.
Yes.
If you could, just describe some of the duties that you do as a constable.
Our main duties is, serving process, serving, going out patrolling your community. Just, and a lot of times, if deputies are out, they have no backup, I go back them up and assist the city with their stuff as well, because I'm in the city down there, so.
Now, I'd like to talk about July 3rd, 2019. Do you recall that date?
I do.
Okay. Where were you physically on July 3rd, 2019?
I was in the hospital.
You were in the hospital.
Right.
Okay. Were you able to perform your duties as a constable, and specifically the service process?
No.
Okay. All right. Approximately how long were you in the hospital?
From July 2nd, I think, till the 5th or 6th. I'm not sure exactly.
Okay. Now, during that time, do you recall anything to do with the process of Christopher Detter's cases?
The only thing I can remember on that was, we done all the paperwork. Rhonda brought the paperwork up to me, which is my wife now. She brought several papers to me. I had to fill out, had to get affidavits and stuff attached, and get it back to Wilson Worley because they want their stuff back pretty quick. And I was filled out, I don't know how many affidavits and things together. And at that point, apparently, I'd done his as well, and didn't click to me, what I'd done until after the fact. And then when it was brought to my attention, then I knew.
Okay. Well, let's go back a little bit. Do you recall this case, or I guess we can refer to it as a case, cases you were trying to serve
Right.
process on?
Yes.
Okay. How many times had you attempted to serve process?
I had made several attempts. I went to his house. Apparently his wife tells me that they was divorced. He was driving a truck. And then you search on Facebook and stuff, which that's a good search point for me. And, then I go to Giuseppe's and,
Well, why would you go to Giuseppe's?
well, that's where his place of employment was listed.
Okay.
So I go there, and then one time,
And Mr. Woods, if we could, and I'm sorry to interrupt you, but if it would help out. So you're at Giuseppe's. Let's talk about the date. When did you go to Giuseppe's?
gosh, I can't recall the date.
Was it before or after you were in the hospital?
Oh, it was way before, yeah.
Okay. So this is a time before July 3rd,
Oh, yeah.
2019.
This had to be somewhere in mid-June probably,
Okay. Okay.
or earlier, because I'd made, I don't know how many attempts to him, so, one time they told me he wasn't working there. Then I go back, another one tells me he's just not there.
Well, we can't say what somebody else told
Well,
you. You could just say, as a result,
right,
were you able to serve the process?
no,
Okay. So, as of July 3rd, 2019, you had yet to serve the papers on this individual.
right.
So, Mr. Woods, then what happened? What happened? What led us here?
It was a total mistake on my part
Okay.
because, I'm being honest about what happened. Then I wind up, about making a mistake with what I done.
Well, I think my question may have been a little misleading. Do you know how these papers were served? Do you have any
Oh,
knowledge?
yes, I do,
Okay.
Rhonda, sir,
And who is Rhonda again?
my wife,
Okay.
my girlfriend at the time.
At the time, it was Rhonda Wills.
Right, right.
Okay. And today, she goes by what?
Woods.
Okay. All right. And how is it that those papers made their way to the hospital?
She had bring them to me. I had several, like I said, to turn in. So
Do you
that-
know how many you had? Mr.
Gosh, I
Woods?
don't have a clue. It's a bunch of them.
Okay.
So-
And a bunch could be,
Yeah, I
20?
would say it's probably at least 15.
okay.
So it's somewhere in that general vicinity.
Were those all in regards to Wilson and Worley?
That's the only person I served for.
Okay. And after those papers made it to the hospital, do you know what happened to those papers?
Rhonda picked them up and turned them in.
Okay.
After I completed everything.
All right. And you get out of the hospital a couple of days later.
Yes.
All right. At any point after you get out of the hospital, excuse me, did you get a phone call about the service process on, excuse me, sorry about that, on Christopher Detter?
Yes.
Okay. Who was it from?
Isaac on.
Isaac on.
Yeah.
Okay. Who testified here?
Right.
Okay. Now, and he's with Wilson and Worley, right?
He,
Do you know what date that was?
gosh, I don't have a clue. It was
Okay.
somewhere after that. I can't recall exactly what day.
Now, do you recall if that conversation concerned the service of process on Christopher Detter?
It did.
Okay. All right. And what, if anything, did you tell Isaac?
You know, I told him, I said, well, apparently I've made a mistake. And, you know, when server, when returning everything I've returned, I said, well, apparently I've made a mistake here. And then he said, well, if you can, come in. And, then we kind of went over it from there. So,
Oh, so come in. Did you physically go to Wilson and Worley in Kingsport?
yes, I did.
Do you recall what day?
I think, I think he testified to the 10th, maybe. I think.
Well, no, it's not if he
Well,
testified.
I don't
If you-
know. I'm
you- if
thinking
you-
he
Okay,
said
you
10th.
don't recall. Okay. Now, what steps, if any, did you take once you arrived at Wilson and Worley?
Well, once I arrived, of course, I waited on him to get a room available so we could talk. And went in, sat down, and he asked me if I served the paper. And I said, no, sir, I did not. I said, Rhonda served the paper for me while I was in the hospital. Of course, they was aware I was in the hospital. And then he said, well, get Rhonda to come in and do an affidavit, showing that she done the service. So,
Okay. Are you aware if Rhonda actually came into Wilson and Worley?
yeah, I think she went in a couple of times, actually.
Okay. All right. Now, the last question, was this intentional?
Absolutely not. Because if it was intent, I would have lied to the attorney right off the bat. But, maybe I try to be a straight shooter. I try to be honest. I don't do that because once you tell a lie, then you got to keep covering it up. And then, being honest got me in no fear. So,
Okay. Do you recall how much time passed after you're at Wilson and Worley's and you speak to Mr. Allen? Right? How much time passed before you spoke to anybody from the Sullivan County Sheriff's Office?
I'm not sure because they called me in up there for an interview sometime. I don't know exactly when it was. It's probably for next month, I'd say, or somewhere into the end of the month or something. I don't know
Okay.
exactly. I can't tell you what date it was.
All right. And then after that interview, what's the next thing that happens?
Well, the next thing
Your Honor, I
happened.
object. I don't would object to the relevance of anything. I mean, he talked about the incident and anything in terms of the investigation is not.
Uh,
All right.
Mr. Woods,
Court
that's all the
sustains the objection.
Oh.
No, go ahead.
Mr. Woods, that's all the questions I have. Please answer any questions that the state.
Gentlemen.
McMurray. I'm sorry, can we press?
Let me wipe it down.
I need to take up a matter with the lawyers. I'm going to try to do that in Judge Rogers' courtroom, if we can get his computer up so we can record it. So y'all stay here. If I can't get that machine working for some reason, then I'll have the officer either take you back here or over there so we can use the recorder here. But it has to be recorded, and I can't do it with you here. So,
Mr. Miracle has a question.
yeah. Is that better? Okay. We have to have a jury out hearing, which means I have to take up a legal issue with the lawyers, and it has to be recorded. So we're going to go next door to Judge Rogers' courtroom and see if we can get that machine working. If we can, we'll just take up the motion there. If we cannot, then I'll have to come back over here, and then we'll either take the jury over there or back here, one or the other, and separate them again. But let me try to do that first. That way you guys have to move the least amount. Okay? All right, we're back now. The court dealt with the legal issue, made a ruling on the record. And General, you may cross-examine.
Yes, sir, thank you.
Judge, I'm sorry, may I grab my notebook?
Yes.
Now, you have testified that you're a constable, correct?
Yes,
And how long have you been a constable?
8 years.
8 years. And as part of being a constable, as I understood your testimony, the primary role is that you serve papers. And if I understood your testimony correctly, you serve papers for Wilson Worley.
Yes, well, I
And-
did.
Correct. Back in 2019. You
Correct.
don't do that anymore.
Correct.
Now, back in 2019, and even in the months and years prior, you've heard Mr. Allman testify that it was that once you served the papers, that the papers were returned to their office, and that papers, I mean the civil summons or warrant, and that you, as the process server, would fill out the affidavit of service.
Right.
And so you did that on more than one occasion.
Oh, yeah.
Okay. And so you understood that that affidavit was a document, a legal document.
Yeah.
Correct.
It's a mistake on my part.
And well, let me ask, and then we'll get there. Okay. So the affidavit is a legal document, correct?
Correct.
And the legal document, the affidavit, was a sworn document, correct?
I guess, yeah, once they seal it, yeah.
Well, I mean, that's what's on the document.
Yeah, okay.
And you knew that.
Yeah.
I mean, you'd seen it multiple times.
Yeah.
And you signed it multiple times. In fact, you knew Ms. Hartsock,
Oh, yeah, well,
and she knew your signature, and she knew you, right?
true.
Okay. And so not only would you sign off on the original civil summons that checked that you had served the individual,
Right.
you also signed that affidavit swearing that you had personally served that individual, correct?
Right.
Okay. Now, of course, you knew that the attorney.
Judge, I would object that question. I believe the question was that you personally served the individual. And would you like us to approach?
Objection overruled.
Now, after you filled out the affidavit of process, your standard procedure was that you would submit an invoice for payment for your services.
Yeah.
And you submitted that to Wilson Worley, and then you were paid for personally serving whichever individual,
Yeah.
correct? Okay. Now, certainly you had done this many, many, many times, correct?
Yeah.
Okay. And you, I guess, worked with Mr. Allman fairly regularly.
Yeah, I worked for the entire team. It's not
So
just-
all the lawyers with
Yeah.
Wilson Worley. And you were aware that they relied upon the service that you provided them and the accuracy of what you provided them in going forward on their lawsuit.
Objection, speculation.
Well,
He's being asked whether or not he was aware if he
right.
knew that.
If he knows, he can answer. If he doesn't, then it's speculation. And so you need to rephrase the question.
Well, if he's aware, which is, I think what I said, Mr. Woods, is that you were aware that these attorneys relied upon you to perform the service you were hired for, correct?
Yeah, I always try to do a good job.
And you knew that they relied upon what you did to go forward with their lawsuit, correct? Right. And you knew that when you filled out that affidavit of service, that they relied upon that in order to go forward with their lawsuit. Because you knew
Which
the
one are you
person had to be
referring
served.
Which one are you referring to? The ones that's supposed to be signed for debtors? Is that the one you referring to?
I'm referring in general.
Oh, yeah.
Yeah.
And Judge, I would object to in general, if you want me to approach.
Okay. Objection sustained in part, overruled in part.
So again, Mr. Woods, you were aware in your capacity as a constable that service of process must be completed and that before they could go forward with their lawsuit.
Yeah.
And by they, I mean the attorneys with Wilson and Wortham. just in case that's unclear. And you also knew that you were the person that was hired to perform that service, correct? Right?
Yes.
Okay. And you were the person that was hired to perform that service with regard to the 2 lawsuits against Mr. Detter, correct?
Well, yeah, but the thing about it is, I get prosecuted for being honest about the whole situation here, and I don't get that. I mean,
Now, Mr. Woods, if you'll just respond to the questions that I asked you. My question was that you were hired by Wilson Worley to serve 2 lawsuits against Christopher Detter.
yes, it is.
Okay. And you did not do that.
No, my wife did.
And you filled out an affidavit that said that you did.
But
Objection,
it was an honest mistake.
objection.
You
objection.
filled out,
What, hold on, he's objecting, come on up here.
Mr. Woods.
Objection overruled, go ahead.
Yes, sir.
And Judge, is that objection noted?
It is, for the record.
So, Mr. Woods, again, you did not serve the papers on Mr. Detter.
No,
And you filled out an affidavit with Wilson and Worley saying that you did.
that's because they was in a whole stack of papers, and I didn't realize what I'd done.
All right, well, let's back up. You had 2 papers, right?
Yeah.
And you've seen the exhibits.
I did.
Okay. And on the exhibits, these are pages 1 of exhibit 1 and 2, right?
Yes.
And on the, may we have him show
That's
just
what I'm
to be
saying. Yeah,
clear?
you're gonna ask him about it, show it to him.
Referring to my name, it's on the front of the paper. correct?
Hold on a second, let me get there. You have in your hand 2 documents.
Yes.
Top page, exhibit 1 and 2, and those you recognize as being the civil warrants filed against Christopher Detter, correct?
Correct.
And on the right-hand side, 3/4 of the way down, there's a box that says service.
Yes.
And that is signed as being served, correct?
But you want me to give you my explanation why it was signed?
Just,
It
just
was prior to this.
give me just a second. The box says it was served, right?
Yeah.
The box below it, or the part below it, says that it was served July 3rd, 2019.
That was what
And
I
it
was
is
there.
signed, that's your signature.
It was, and if you'll let me
As-
explain why it's there.
I'll give you just a chance. And it was signed as you serving Mr. Detter on July the 3rd.
And
No,
Judge, if
it
we
wasn't.
just
Didn't
note
have a
my
date on it
objection.
That particular time when his signature was put up, well, mine was put on there. I went to his work. I knew he was there. And I asked the guys, I said, can you go get Mr. Detter?
Now, I'm not asking you what anybody
Well, I know,
else
but
said.
I'm just telling you what happened.
I understand
That's
that,
the
but there's
process.
legal rules, and I'm not asking you what anyone else told you.
Well, I don't know what else to say.
Well, you didn't serve Mr. Detter
No.
on July the 3rd, the way this paper says.
No.
Okay. And that would be with regard to both of those exhibits, 1 and 2.
Right.
Okay. And the admission, when you're talking about the admission at the hospital, that was a voluntary admission at the hospital between July the 2nd and July the 5th, correct?
Yeah.
Okay. And then on July the 8th, do you still have those exhibits,
I
sir?
do, yeah.
Okay, on the second page of both exhibits, that's the affidavit of service, correct?
Yes.
And both of those, you have those in front of you.
And it says 7-3 on
Right, the affidavits say that you served Mr. Detter on July the 3rd.
well, that's, yeah.
And it's signed, though, in front of Ms. Hartsock, you know Ms. Hartsock, on July the 8th of 2019.
No.
So you deny that you signed it on July the 8th of
I
2019?
did not turn these in to her.
Okay, so when she said that you appeared at their office on July the 8th, and she either saw you sign it or affirmed your signature, is it your testimony that Ms. Hartsock is not telling the
No,
truth?
I didn't say she wouldn't tell the truth. My wife turned these
Okay. Okay. But you, of course, heard her testify here today
in. Right.
that you were there on the 8th and that she either saw you sign them or affirmed that that was your signature.
Yes.
Okay. Here, may I have a moment? Your Honor, the state has no further questions.
Redirect Mr. McMurray.
Very pretty. Mr. Woods? Mr. Woods, do you still have those exhibits?
I did.
If you could turn to page 2, that affidavit of service. Let's talk about that. I served 2 p.m. on July 3rd, 2019. To your knowledge, was Mr. Detter served on July 3rd, 2019?
He was served, yes.
By who?
Ron, my wife.
So to your knowledge, that is correct.
That is correct.
Okay. All right. Was it, to your knowledge, by a personal hand service?
It was.
Okay. So that's correct.
That's the reason we got a signature.
And explain that. Got a
Well,
signature.
he has to sign off on the front. Anybody you serve, signing off saying that they received service.
Yeah, but, all right, signed off on the front. Are you referring to that civil summons?
Yes, I'm referring
Okay.
to the summons. They have to sign off on the front showing that they received a copy of the original paper sheet.
Okay, so Mr. Detter signed off on the first page, right? And so it was personally given to him by hand.
Right.
And to your knowledge, it was on 2 p.m. on July 3rd, 2019.
Yeah, as far as I know, that's what she said.
Okay. All right. That's all the questions I have.
Judge, I can just ask from here.
That's fine.
You're not telling this jury that this affidavit of service in any way says that Rhonda Wills served that paper.
There's a,
Now, just let me ask the question. You're not telling this jury that anywhere on here it says that Rhonda Wills served Christopher Detter. That's not what this paper says.
no, what it
No.
says, but that's what happened.
Well, it may be what happened, but it's sure not what is on this paper.
Well, there's another affidavit.
Objection,
that says
Judge.
so.
She's
That paper
testified.
was not filed with Wilson and Worley until after they contacted you.
Hold on. Did you object?
I did. And she just,
Sustained. General, rephrase the question.
So that's not what this paper says, is it? That's all good.
Other questions, Alex?
You can step down, Mr. Woods. Thank you. If you'll hand him back, there you go. I was gonna say, hand him back the exhibit.
Hey Doug, I think you're gonna have to wipe it off.
He'll do it. Call you next.
Judge, the defense calls Rhonda Woods. She's outside. She is.
Yeah.
Yeah, if you'll go around, just go get her and bring her through the door back there.
Bring it through back there.
No, bring her on the side door. Did you leave the computer up there running over there, or did you shut it off? So they get to go back. We'll go back over there in a few minutes. When the proof's over, to do the jury on the charge.
Do what?
That way they can stay here or go outside if they want to.
Mhm.
So they run this affidavit. See what you see.
Judge, can I approach real fast? Okay. Do you recall serving any papers on July 3rd, 2019? Okay. Do you recall who you served those papers?
Christopher did.
Okay. Do you recall that process?
Yes.
All right. Could you explain it to the jury?
I went to, and it's not just Seppies, it's Bradley Hills. Just
Right.
with Bradley Hills. I went to, his home.
When you say
I'm
his,
sorry.
I
Excuse
went-
me just a minute.
You can't hear her.
Okay. Ma'am, I need you to scoot up and speak into the silver microphone.
She said
Bring
if
the
she-
silver
if
one.
They brought the mic down just a little.
And bring the silver one down, is the one we need. There you go. And speak up for us, okay?
I started my
Wait,
day.
Hold on.
I'm sorry,
Hold
so
on.
give us just a moment, please.
I noticed that, but we just.
Can we just simply take this forward and let you, for the court, have
Yeah,
discussion?
sure. Everybody. We'll have to take everybody back over there. Yes, he's right. Okay. All right. Ladies and gentlemen, there's a legal issue I've got to take up again. So I'm gonna step next door so I can put it on that recorder. There's a legal issue you can't hear me through this thing either. There's a legal issue I have to take up, and we're gonna go next door again, just like we did, so you all don't have to move. If you all do want to go outside and get fresh air, or if you need a drink or a bathroom, you'll have time to do that, okay? So I'll be back just as quickly as I can, and we'll resume with this witness. All right. As soon as we get the parties back in, we'll get started. In Judge Rogers. It's fine, Joe. It's fine. Okay. You have your original? All right. Ladies and gentlemen, we did two things while we were at break. First, Ms. Woods is not going to be allowed to continue testifying. She's not in trouble. She didn't do anything wrong. But there's a legality that came up during the beginning of her testimony that's going to prohibit her from being able to continue. There was one document that Mr. McMurray was going to introduce through her, and the court has ruled that that document will be entered as evidence. Do you have the document, Mr. McMurray?
Judge, I do, and I just gave it to the bailiff.
Okay, that'll be Exhibit 4. It is?
It is. There's two affidavits.
Oh, there's two of them. Yeah, right.
Two cases. And I would ask that they be published to the jury.
All right. There'll be full exhibits number 4. All right. Those exhibits have been published to the jury. Mr. McMurray, do you have any other witnesses?
The defense rests.
All right. General, does the state have any rebuttal proof?
No, Your Honor.
All right. At this time, the proof has closed, and we will proceed to the reading of the jury charge. And ladies and gentlemen, I'm going to hand out a copy of the jury charge to each of you. It is the charge as I'm going to read it to you, minus the actual verdict forms that are at the end of this booklet or notebook. That way you can read along with me, and when you deliberate, you'll have a copy of the charge you can refer to throughout your deliberations. All right. Can everyone hear me okay? In the criminal court for Sullivan County, Tennessee at Bluntville, State of Tennessee versus Doug Woods, defendant, case number S72141, date 24 and 25. August 2020. Count 1, perjury. Count 2, perjury. Jury instructions, members of the jury. Count 1 of the presentment in this case charges the defendant. I knew it. So anytime I see a mistake and I have to make a change, the official jury charge is what is in the black notebook, okay? And whoever you elect as your foreman or a foreperson, they will have custody of the black notebook, and that's the official. Everybody understand that? Okay. Members of the jury, count 1 of the presentment in this case charges the defendant, Doug Woods, with the offense of perjury. This offense embraces the lesser included offense of attempt to commit perjury. Count 2 of the presentment in this case charges the defendant, Doug Woods, with the offense of perjury. This offense embraces the lesser included offense of attempt to commit perjury. The presentment in this case is the formal written accusation charging the defendant with these charges. It is not evidence against the defendant and does not create any inference of guilt. To this presentment and each count thereof, the defendant has entered a plea of not guilty. The evidence in this case has been completed and final argument will take place momentarily. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks that I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection. And you must assume that the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court. Such matter is to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked of a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural unless clearly inapplicable. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. The law presumes that a defendant is innocent of the charge against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim. It is not a speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. The state must have proven beyond a reasonable doubt all the elements of the crime charged, and that the crime, if in fact committed, was committed by the defendant before the finding and returning of the presentment in this case. The date of the offense is not an essential element of any of the offenses charged in the presentment or any lesser included offense. The state is not required to prove beyond a reasonable doubt a specific date upon which any of the alleged offenses occurred. The state is only required to prove beyond a reasonable doubt that the alleged offenses occurred before the finding and returning of the presentment in this case. The burden is upon the state to prove by preponderance of the evidence that the offense was committed in Sullivan County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was committed or consummated in Sullivan County, Tennessee, then you must return a verdict of not guilty. If you have read or heard anything about the case other than in open court, you should disregard what you read or heard and base your verdict only upon the law and evidence presented under the direction of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experience in life. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved in the trial. Your decision on the facts of this case should not be determined by the number of witnesses testifying for or against a party. You should consider all of the facts and circumstances in evidence and determine which of these witnesses you choose to believe or not to believe. The defendant has testified in his own behalf, and his credibility is determined by the same rules by which the credibility of other witnesses is determined, and you will give his testimony such weight as you think it is entitled. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial, alleged to show an admission against interest. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven or to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the fact stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide the statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Evidence. You may have heard two types of evidence in this case. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. The crime charged or included in count 1 of the presentment is a separate Let me start that sentence over. The crime charged or included in each count of the presentment are separate and distinct offenses. You must decide each charge separately on the evidence and law applicable to it. The defendant may be convicted or acquitted on any or all of the offenses charged or included. Your findings as to the crimes charged must be stated in your verdict. You will not be provided with a transcript of the testimony. However, you were permitted to take written notes. Notes taken by a juror are to be used only as an aid to the memory of that juror alone and may not be used as authority in the jury deliberation room. The fact that something has been reduced to writing does not make it more significant than matters not noted down, and does not make it more accurate than independent memory. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic devices or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, Snapchat, LinkedIn, YouTube, Twitter, or any social media platform, to communicate to anyone any information about this case or to conduct any research about this case until you have returned your verdict and the trial has concluded. The court will now instruct you as to the law applicable to all counts of the presentment. Counts 1 and 2, perjury. Any person who commits the offense of perjury is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant made a false statement under oath, and 2, that the statement was made with the intent to deceive. Intent, statement, and oath are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of perjury, then you may fix a fine in any amount not greater than $2,500, and you will so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of perjury as charged in the presentment, then your verdict must be not guilty as to this offense. Criminal attempt. The following definition applies to the attempt to commit any criminal offense that is charged or included as a lesser offense in these instructions. Any person who attempts to commit any criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt to commit any criminal offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specified criminal offense, and 2, A, that the defendant did some act or caused something to happen that would have constituted the specified criminal offense if the defendant's beliefs at the time he acted had in fact been true, or B, that the defendant did some act intending to cause an essential element of the specified criminal offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part, or C, that the defendant did some act intending to complete a course of action or cause a result that would constitute the specified criminal offense under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit are as follows. Count 1, attempt to commit perjury, max fine, $500. Count 2, attempt to commit perjury, max fine, $500. Definitions. Intentionally or intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Oath means a solemn and formal undertaking to tell the truth and includes an equivalent affirmation permitted by law as a substitute for an oath administered by a person authorized by law to take statements under oath. Statement means any representation of fact. Deliberation process. Each count of the presentment is a separate offense and you must deliberate on each count. When you begin your deliberations on each count of the presentment, you must first deliberate on the indicted or charged offense. If you unanimously find a defendant guilty of the indicted offense, you may stop your deliberations as to that count of the presentment. You would then begin your deliberations at the remaining counts of the presentment. If you unanimously find the defendant not guilty of the indicted offense in each count, or you have a reasonable doubt, then you must unanimously find a defendant not guilty of the indicted offense and next consider the lesser included offenses in each count as set out below and in your verdict form. The order in which you are to consider the charges and the lesser included offenses in each count is as follows. Count 1, perjury, 2, attempt to commit perjury. Count 2, 1, perjury, 2, attempt to commit perjury. The essential elements for each offense of each count of the presentment have been previously set forth in these instructions. Please refer to those essential elements as you deliberate on the charged offense or lesser included offense of each count of the presentment. Fines. If you find the defendant guilty beyond a reasonable doubt of an offense, you may in your discretion fix a fine in any amount not to exceed the amount listed for that offense in these instructions and on the verdict forms. If after considering the charged offense and the lesser included offense in each count as set out above and in the verdict form, you find the defendant not guilty or have a reasonable doubt as to his guilt as to all counts and offenses, then you must return a verdict of not guilty and acquit the defendant. In considering the charged offenses or lesser included offenses in each count, in this case, do not consider the punishment. If you find the defendant guilty of any offense of any count, the court will set the punishment at a separate sentencing hearing. You'll be provided with a form for all possible verdicts in this case, and it will be at the back of these instructions. The jury will mark the appropriate verdict on the form by checking the box next to your verdict, and your foreperson will sign and date the verdict form. The verdict forms which you will receive read as follows. In the Criminal Court of Sullivan County, Tennessee, at Blumble, State of Tennessee versus Doug Woods, defendant, case number S72141, verdict form count 1. We, the jury, find the defendant Doug Woods, mark the appropriate 1. Checkbox 1, guilty of perjury, fine in an amount of $blank, not more than $2,500. Or checkbox 2, guilty of attempt to commit perjury, fine in an amount of $blank, not more than $500. Or checkbox 3, not guilty, foreperson, signature line, date, blank. The same heading, verdict form count 2, we, the jury, find the defendant Doug Woods, mark the appropriate 1. Checkbox 1, guilty of perjury, fine in the amount of $blank, not more than $2,500. Or checkbox 2, checkbox 2, guilty of attempt to commit perjury, fine in the amount of $blank, not more than $500. Or checkbox 3, not guilty, foreperson, signature line, date, blank. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find the defendant not guilty. We're going to stop there. We're going to let the parties argue their case. And General, you may open on behalf of the state.
Thank you. Ladies and gentlemen, thank you for your time and attention over the last 2 days. The court has instructed you about perjury. The charges for your consideration are perjury. The court has instructed you that the state must prove beyond a reasonable doubt that the defendant made a false statement under oath and that the statement was made with the intent to deceive. That's perjury. The court has also instructed about the oath. And the oath, again, is a solemn and formal undertaking to tell the truth, includes an equivalent affirmation permitted by law as a substitute for an oath administered by a person
authorized to take statements under law. Ladies and gentlemen, I submit to you that the proof has been that there was a sworn statement by the defendant made under oath. Twice, two statements. The first affidavit of service in case 45842, and the second affidavit of service in case 45844. Signed by the defendant, sworn to under oath, and notarized by Patricia Hartsock. You heard the testimony of Isaac Allman, the attorney for Wilson Worley, whose firm hired Doug Woods in his capacity as a constable to serve legal process on an individual. You heard Mr. Allman tell you that service of process is a constitutional due process right to each and every one of us and every person in society, that they receive proper service of process of any civil proceedings that have been taken out against them. You heard Mr. Allman testify about the importance and the requirements by law that those rules are followed. And they relied upon the defendant in this case to comply with those rules. You also heard from Patricia Hartsock, and she testified that she was a notary, and that because she's a notary, she is a person authorized by the state of Tennessee to take an oath and swear to someone or affirm their signature on a legal document. And so that meets the requirements set forth under Tennessee law for the charge of perjury. You also heard her testify that her practice was that she either saw the person, that she always followed. She either saw the person sign the documents or she affirmed their signature in her presence when she notarized the document, that was their signature. And in fact, she told you that she knew Doug Wood's signature. Mr. Allman told you that when he appeared in court, that the service of process affidavit filed and signed, or signed by the defendant and filed by his office, was in the court file. And that Mr. Detter was there, and that based upon a conversation with Mr. Detter, that he became quite concerned about whether proper service had been done and whether or not that affidavit was correct. And he told you that he contacted the defendant, that the defendant came to his office, and that they had a conversation, and that the defendant told him he did not serve the papers. And really, that's undisputed. That's undisputed. And what's also not disputed are the affidavits that are been introduced as exhibits. Those are exhibits 1 and 2, page 2. The affidavits are identical with the exception that they have a different case number. There is no doubt that these are sworn legal documents taken under oath and notarized by Ms. Hartsock. That's the evidence. And the evidence is that the information contained in this affidavit is false. It's false. Now, I do want to point something out. The defense introduced Exhibit 4 and 5. And those are, again, affidavits of service. And they reference the 2 case numbers. And those are filled out by Rhonda Will. And those indicate that she served those papers to Christopher Detter on July 3rd. One thing that I would point out to you is that on her affidavits, both of them, it indicates that Christopher Detter was served at 6:30 p.m. on July 3rd. Now, it looks like one of them indicates it was served on July the 10th, but the time on there is 6:30. If you go back to the exhibits 1 and 2 and the affidavits filed by the defendant or by the state, the affidavits filed by the defendant, signed by the defendant, they indicate that service was at 2 o'clock. So point that out to you. And so, ladies and gentlemen, in the course of the cross-examination, Mr. McMurray asked Mr. Allman, he went through it and asked him a lot of questions about the affidavit of service. Is this correct? Is this correct? Is this correct? Is this correct? But ladies and gentlemen, you all, I submit, understand that the issue is this. The issue is, did the defendant sign an affidavit saying that he hand-delivered personal service to Christopher Detter on July 3rd of 2019? Was it with the intent to deceive? And I submit to you that the evidence is he did not personally serve him, and he signed an affidavit that said that he did. Now, I can't speak for Mr. McMurray, but he may get up here and say, well, ladies and gentlemen, it doesn't say on here, I personally served Christopher Detter. And I would state to you that Constable Woods, who did this many, many times, according to his testimony, he knew that the defendants or that the attorney that he worked for relied upon him to follow the law and to follow the process. He signed an affidavit, gave it to the attorney's office, knowing full well that they would rely upon that. And he didn't do it. He didn't do it. And so the argument may be, it's not a legal defense, but no harm, no foul. He got served. He got hand delivery by the right person. But ladies and gentlemen, that's the law. That is the law. And he knew. He's a constable. He served process. He was hired. And the most important thing is, he swore to it under oath that he did it. And he didn't do it. And because of that, he is guilty of perjury 2 times for both affidavits that he signed and that were filed. Ladies and gentlemen, at the beginning of this case, we talked about the fact that the state has the burden of proof, and the courts instructed you to that, and we've talked about that. The state has the proof beyond a reasonable doubt. And one of the things that we talked about was that even though the defendant doesn't have to put on proof, if they do put on proof, you all agree that it doesn't, just by virtue of putting on proof, create a reasonable doubt. It was up to you as a trier of fact to listen to his testimony, weigh his credibility the same as you weigh the credibility of the state's witnesses, and then make a determination. Ladies and gentlemen, after hearing all the proof, looking at the exhibits, judging the credibility of the witnesses, looking at each one of these exhibits, I submit to you that the state has proven beyond a reasonable doubt that the defendant is guilty of perjury in count 1 and perjury in count 2.
and I ask you to find the defendant guilty. Thank you.
Thank you, Jennifer. Mr. McMurray.
Thank you. I think when we started out, I gave an opening statement. I said I lost sleep. And I believe the state said this was straightforward. So I think we're at a point now where we know that one thing we have proven is that the affidavits, that was a mess. And actually, the state even proved something that I would, or mentioned something that I was going to bring up in my closing, is that the affidavits by Rhonda Wills at the time, that was her name, Rhonda Wills, they're even wrong. One of them, and that's on 4-2, if y'all want to turn to it, I don't know the exhibit number. It could either be 4 or 5. One says July 10th. I agree. We need accuracy. I agree. We need to be precise, especially as attorneys. We do. But also at the same time, I submit to you, we are human, each and every one of us, and we make mistakes. I can't help but notice, hopefully I don't get admonished for saying this, but the jury instructions had some mistakes, just 2. We corrected them, right? We did. But when we started out, everybody raised your hand. Yes, there is a presumption of innocence here. You agreed with me. You told me you would. And everybody raised your hand. Yes, I'll hold the state to that verdict beyond a reasonable doubt. Now, ladies and gentlemen of the jury, I know you've been through a lot. You've gotten up, you've worn masks all day, and you've gotten up and you've had to move around, and it's been confusing. If you could, just bear with me just for a little bit while I speak as to some of these issues. I submit to you that even the mistake itself doesn't rise to the level of this crime. And that's why I wanted to be so precise. If you could, please turn to that Exhibit 1 that the state introduced. If you will recall, I asked the state's witness, Mr. Allman, who was very forthcoming, who I said, this first page, the summons, or he called it the civil warrant. Did my client sign an oath or swear to an oath on this page? No, he did not. I said, okay. So it's the next page. Is that right, Mr. Allman? That is correct. We went through line by line. Plaintiff, Eastman Credit. Technically, it's Eastman Credit Union, but I don't think he's charged with that. Versus defendant, Christopher Nile, that's true. Defendant to be served civil summons, that's true. Case number 19BK458842, that is true. Type of service, personal service by hand. Technically, that is true. We know that by the exhibits that you all just received, 4 and 5. If you want to turn to them just real briefly. We've got affidavits there. From Rhonda Wills at the time, it's actually Rhonda Woods. And this was before the criminal prosecution. She even swore to it, and it's not at issue. She's not charged. She swore to it that she handed him. It's personal service. She handed it to him personally. And to corroborate that, guys, if we'll turn back to Exhibit 1, page 1. Okay? I know. Hopefully we're not going to get paper cuts. But if you look, there's a signature. It's on the top right. That's Chris Detter's signature, according to Isaac Allman. Oh, no, I'm sorry, according to Mr. Woods. So there was personal service. Okay? And if I could just very briefly, let's turn back to that page 2 on that. Okay? So we dealt with top of service, received this for process on Christopher Detter. Well, that's true. According to Mr. Allman, that's the state's witness, not my witness. Served 2 p.m. 7/3/2019. Now, as far as we know, Mr. Woods testified that is true. And I haven't heard any contradictory evidence that the time is wrong. In addition to that, that is not what the state believes that Mr. Woods lied about was the time. That's not what they're saying that he falsified. So then we have individual service, that box is checked. Well, that's still true. And then there's 2 separate addresses, I guess you could say address. 4309 Fort Henry Drive, and then comma, work Raphael's. So that is where it attempted to be served. Then at the bottom, I certify I am not a party to the above action. Well, that's true. He's over the age of 18 years. We haven't had any testimony to that, but again, it's beyond a reasonable doubt, guys. And the above affidavit is true and correct. Everything above we just went over. Let's turn to State's Exhibit number 2, okay, if we can. Turn to State's Exhibit number 2. That's 44. What I say is 44. 4K 844. Guys, it mirrors State's Exhibit number 1. Okay, so it's 2 separate suits, but it's basically the same thing. Now, I will admit that the state's witness, Mr. Allman, he admitted that everything on the affidavit of 42 was true and correct. Everything we went over was true and correct. But on 44, he took issue. Okay, guys, I submit to each and every one of you. Find the difference between the affidavit that's on 44 and the affidavit that's on 42. It's plaintiff, Eastman Credit Union. Defendant, Christopher Nile Detter. Defendant to be served civil summons, case number. Now that is a difference. There is a different case number. But again, the state is alleging that Mr. Woods lied about personal service in this document. But we've got an affidavit in your hands that there was personal service. There was. So before I even get to the intent versus the mistake, I think we need to address just the glaring issue with the documents and the testimony that we've heard. But I am a lawyer, and I guess I will belabor the points. As far as the mistakes, I'd submit to you that there's been mistakes every day, and there's mistakes even in doing our job here today. But we can't hold each person to a standard that every mistake rises to a crime. There has to be something behind it. And that motivating force, that is the intent to deceive. And Mr. Woods' testimony was, as soon as they called me, yes, I told them there was a mistake. Mr. Woods' testimony, he went down there and corrected it. Ladies and gentlemen, I would submit to you that you even heard from Isaac Allman. Isaac Allman, that's a state's witness, that this gentleman, Chris Detter, had been evading service. That's why it says alias. So this guy, you can't get a hold of, okay? That, according to the paperwork, owes money around town, okay? So you're going to believe Chris Detter's word over my client, Doug Woods? I would submit to you that if, in fact, Doug Woods had the intent to deceive anybody, it would have been easy. He would have done it right then. No, Isaac, I did that. They can't find the guy half the time. Who would have been the wiser? But he owns up to it. And he's sitting in that chair. We spent all day, and even the affidavits that they got on file right now aren't even right. Don't tell Christina, whatever you do. But, ladies and gentlemen, and that's why I can't sleep sometimes at night. It's just my words and your good conscience. And everything you heard here today, once it passes that bar right there, right? Justice comes back. It's you all. It's you all that tells us. We sit up here, we yarn and we argue all the time. That's what we do. But you all, your conscience tells us, is this a crime? Is this what we need to prosecute? I'd submit to you that it's not. And my client, Mr. Doug Woods, is innocent. Thank you.
Thank you, Mr. McMurray.
Heard a lot of talking over the whole course of this. Ladies and gentlemen, when you walked in that back door, you didn't leave your common sense in the car. You brought it with you. And the law permits you to use your common sense in reaching a decision in this case. Now, when I was a little girl, in fact, when I was born, my grandfather had already passed away. But my granny was living. And I would visit my granny, and she would tell me stories about my grandfather. My grandfather was a farmer, and he bought and traded and sold cattle. And so this was in the 1940s when he did this, 1940s and 50s and on until the time of his death. And he had a saying that my granny passed on to me. And one of his sayings was, my handshake is my word is my oath. And I submit to you that your word is your oath. And your oath is what you swear to be truthful when you sign a legal document. There's been a lot of talk about mistakes. And I'm not going to stand here and say mistakes aren't made. People make mistakes all the time. A mistake is a typo on jury instructions. That's a mistake. But I submit to you that it is not a mistake to swear on a legal document under oath that you did something that you did not do. That's perjury under the law of the state of Tennessee. And that is the evidence that you heard here today. And I submit that based upon the law and the evidence, that the defendant is guilty beyond a reasonable doubt. And I ask you to so find. Thank you.
Thank you, General. Looking back on your jury instructions at page 14, when you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict form to the court. If I get the lawyers to approach. random number generator. Between 1 and, all right, between 1 and 14. 14. And 4. Those are the two alternates. Okay. Miss Taylor and Miss Billings, you are the two alternates. Tracy, if you will take them just out the front, they're free to go. Just leave your notebooks in the seat. Thank you for your service. Call Friday from Monday, but there's no trial Monday. You may have to call Monday for Tuesday. I'm not sure about Tuesday yet. Okay. Oh, and if you want to stop by the clerk's office, they should have the dates for September. And what I told you about, I didn't know how long you would serve. I'm only going to extend you through September, and we're going to bring a new jury in to start over in October. Okay? Now I need Steve. Everybody stay right there. Hold on. Huh? All right. Take with you the presentment, exhibits, verdict forms, and the court's written instructions, and you may retire and consider of your verdict. And what I'm going to do is I'm going to have Lieutenant Wetzel take you over to Judge Rogers' courtroom where you can spread out in those seats, the tables, the jury box, wherever you want to spread out, and you can deliberate there in private. If you need a break for any reason, let one of the officers know. If you need water, coffee, to go outside or whatever, let him know.
Everybody will bring all their goodies. Drinks or anything like that.
Yeah, when he gets back, I'm gonna have one of them handed to me. All right, the jury has gone out at 3:43 p.m. General Nelson,
Yes, sir.
will you hand me Miss Billings' notebook?
I will. There's a pen here as well.
Just leave it. Just leave the pen.
Judge, are we free to leave the courtroom?
Yes, we'll be in recess until the jury comes back. And for the record, and so you know, I'm going to make the copy of the notebook that I handed out to the jurors. I'll make that Exhibit A for identification only. So that'll be part of the actual record. And then any notes or anything else that she had, which I'm not going to look at, Lieutenant Wetzel will destroy afterwards.
Okay, thank you.
All right, we'll be in recess waiting on the verdict of the jury. We'll resume the live stream when the jury comes back. It's okay. You won't need it right now.
Okay. I mean, he said I didn't need it.
All right. It's 5:03. The jury has a question. They've reduced it to writing. I'm going to hand it down and let each of you read it. We're back on the live stream. I'm gonna have each of y'all read that. While you do, I'll talk. As each of you know, any response that the court gives the jury at this point has to be in writing. And the court is also limited on things that I can and cannot say.
I don't know.
So what I'm going to do as soon as I can find my place here. Just prepare supplemental instruction number 1. So basically what I'm going to tell them is that the jury has heard all the evidence properly admitted in the case. The court may not supplement nor comment on the evidence that has already been introduced. You should base your decision on the evidence that you have heard in this case. And then I'm going to go back. They have my book. But let me see. I'm going to go back and also put in and reread. The verdict must represent the considered judgment of each juror. In order to reach a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. I think that's all I can say. Do you agree, Ms. General?
Yes, Judge.
Do you agree, Mr.
I do, Your Honor.
McMurray? All right. So we'll take a short recess while I prepare this supplemental instruction. I have to type in the question and then type in the court's response. So it'll take me just a minute. And then what we'll have to do is we'll have to bring the jury in. And read that to them. Okay.
Do you want us to stay down here, Judge?
Yeah, it won't take me but a minute.
Okay.
Shoot, I didn't hole punch it. There's that. Oh, what is this? Okay. Let me read this to you. Members, supplemental instruction number 1, members of the jury. Each instruction to you or response by the court to any request from the jury is required to be reduced to writing. You are not to place undue emphasis on this response. This instruction should be carefully considered along with all previous instructions in light of and in harmony with the others. Question 1, the jury does not agree on the defendant is guilty, but not number 2. Note is 10 not guilty, 2 guilty. 4 persons signed Eileen G. Gifford, Eileen 8/26/20. Court's response is as follows. The jury has heard all the evidence properly admitted in the case, or in this case. The court may not supplement nor comment on the evidence that has already been introduced. You should base your decision on the evidence that you have heard in this case. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Take with you this instruction along with the court's previous instructions, the exhibits, and the presentment. Retire and consider your verdict. And then I've attached the original question to the back of that response. Any objection by the state?
No, Your Honor.
Any objection from the defense?
No.
All right, we'll bring the jury in.
You want me to bring all this stuff or just the black?
Just the black one. They can leave their notebooks where they are, sit where they are. Everyone stand. Y'all can be seated. All right. Ladies and gentlemen, your written question has been given to the court, and I've discussed this with the lawyers. I'm sure you won't be surprised that I have to reduce these to writing. So supplemental instruction number 1, members of the jury. Each instruction to you or response by the court to any request from the jury is required to be reduced to writing. You are not to place undue emphasis on this response. This instruction should be carefully considered along with all previous instructions in light of and in harmony with the others. Question 1. The jury does not agree on the defendant is guilty, but not number 2. Note, is 10 not guilty, 2 guilty, 4 person with signature and date. The court's response is as follows. The jury has heard all the evidence properly admitted in this case. The court may not supplement nor comment on the evidence that has already been introduced. You should base your decision on the evidence that you have heard in this case. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. Take with you this instruction, along with the court's previous instructions, the exhibits, and the presentment. Retire and consider your verdict. And I've attached the original question to the response, and I'm going to place that in the notebook.
Everyone stand, please. And we're just heading back.
Everybody be seated. The jury has returned to deliberations at 5:20 p.m. and we'll be in recess waiting on the outcome of the jury. All right. It's 5:52. I've been told the jury has a verdict. State ready to proceed?
Yes, Judge.
Defense ready to proceed?
We are, Your Honor.
We're ready. Bring the jury in.
Stand, please. Everyone, please be seated.
Who's my fourth person?
Let's get it.
Um, no, I don't want her to.
Your Honor, I think we could all hear her from the.
I just want to make
audience.
sure you put your headphones on and state your name.
Eileen Gifford.
All right. I understand the jury's reached a verdict. Is that correct?
Yes.
I don't have the verdict forms. They're not in there.
The verdict forms that you filled out.
I put it with the, like, number. I think. I give it to you.
All right. Can I get the lawyers to approach? You may want to step over, Kathy. Supplemental instruction, number 2, members of the jury. Each instruction to you or response by the court is required to be reduced to writing. You are not to place undue emphasis on this response. This instruction should be carefully considered along with all previous instructions in light of and in harmony with the others. Your verdict must be unanimous. Therefore, you can only check one option on each verdict form. Take with you this instruction along with the court's previous instructions, the exhibits, indictment, retire and consider your verdict. Put this together. I've got them. I'll put the verdict forms back in here. I'll tell you what I'm gonna do. I'm gonna print a new verdict form. Can y'all come up here real quick? Yeah, right here. I'm gonna print 2 new verdict forms. 2 new verdict forms. Let's see that. All right, be seated. The jury has returned to deliberations due to error on the verdict forms. That's why the court gave supplemental instruction number 2. And we'll be in recess. It's 6:05. We'll be in recess waiting on the verdict. I understand the jury has a verdict. It's
Yes.
six,
Yes.
it's 6:09 PM. State ready to proceed.
Yes, Your Honor.
Defense ready to bring jury in.
We are, Your Honor.
All right, let's bring the jury in.
Everyone, please be seated.
Ms. Gifford, I understand we have a verdict.
Pardon?
I understand we have a verdict.
Guilty.
Well, hold on.
So what did I not get this time?
No. I need you to look at the verdict forms. And if you want to pull that down so we can hear you, that's fine.
I can read.
Right. And with regard to count one, you don't have to read the part where it says the heading. You can start with "we, the jury." And will you read that, please?
We, the jury, find the defendant, Doug Woods, Mark, the appropriate one, guilty of perjury.
And did you assess a fine?
We did. We felt like he needed to pay back what he was paid,
And how much was the fine?
$40.
Ladies and gentlemen, you've heard your foreperson deliver the verdict for count one of guilty to perjury with a $40 fine. If that is each juror's individual verdict, please raise your right hand. Let the record reflect that each juror has raised their right hand. Will you read count two?
We, the jury, find the defendant, Doug Woods, guilty of perjury, the amount of the fine, $40.
Ladies and gentlemen, you've heard your foreperson deliver the verdict in count two of guilty to perjury with a $40 fine. If that is each individual juror's verdict, please raise your right hand. Let the record reflect that each juror has raised their right hand. General, do you desire individual polling of the jury?
No, Your Honor.
Mr. McMurray, do you desire individual polling of the jury?
I do, Your Honor.
All right. Mr. Leonard, in count one of case 72141, what is your verdict? In count two, what is your verdict? Ms. Fugit, in count one, what is your verdict? In count two, what is your verdict? Mr. Queen, in count three, you're juror number three. In count one, what is your verdict? Count two, what is your verdict? Ms. Copenhaver, in count one, what is your verdict, ma'am? In count two? Let the record reflect that she said guilty in both. Ms. Wallace, in count one, what is your verdict? In count two, what is your verdict? Mr. Miracle, in count one, what is your verdict? Count two, what is your verdict? Ms. Goodwin, in count one, what is your verdict? In count two, what is your verdict? Ms. Gifford, in count one, what is your verdict?
Guilty.
In count two, what is your verdict?
Guilty.
Ms. Knight, in count one, what is your verdict?
Guilty.
In count two, what is your verdict?
Guilty.
Ms. Larkins, in count one, what is your verdict? In count two, what is your verdict? Ms. McCann, in count one, what is your verdict?
Guilty.
In count two, what is your verdict?
Guilty.
And Mr. Hale, in count one, what is your verdict?
Guilty.
In count two, what is your verdict?
Guilty.
All right. Let the record reflect that upon individual polling, each individual juror has stated the verdict of guilty in both counts. At this time, I propose we release the jury from service in this case. Any objection, General?
No, Your Honor.
Any objection, Mr. McMurray?
No.
Judge, Ms. Gifford, if I'm saying that correct, says she has an issue with the September.
Okay. If she'll stay until we
Okay,
stop here, I'll talk to her.
just sit there for just a moment.
Before I let you go, with regard to not the case itself, but the process, I wanted to get y'all's feedback. Any complaints, any suggestions for how to improve the process other than going faster? I can't necessarily make that happen. Miss Wallace?
I think we need more instructions when we ask the question. It was a point of law that we were asking about. Guilty had to include 1 and 2 on page 9 and 10.
You know,
Why was that not answered? I think that would make the process bad.
it's incredibly restrictive as to what I can say. You are not the first juror or jury to ask a question like that, only to find out that I can't answer it. Even though it may be a question of law and fact, once what the instruction is given, I can't go back and supplement either facts or law. And it's just, I hate to have to say this, but it's the way the law is written. My hands are very much tied in what I can and can't say to the jury. And I apologize for that. If I could have said more, I would have said more. Any other observations? Yes, ma'am?
I have a question. So like when you're seating the jury, do you have to actually be present in the actual room where the lawyers are when you're getting ready to seat them? Because that seemed like a very long drawn out process.
Yes, it's longer now because normally what happens is I put 18 people up here
And I understand that, yeah.
and then I have everybody else back there.
Right.
So they ask their questions once to these folks and all those folks hear the questions.
Right.
And it takes it's a fraction of the time on that second round and third round
Right.
because everybody out there has already heard the questions.
So there's no way they could put like a screen out there in the waiting area?
I'm thinking that during voir dire for the next trial we have,
Right.
if there's nobody in Judge Rogers' courtroom or upstairs in that courtroom,
Right.
I'm going to set up a video monitor
Yeah.
so that at least while you're sitting there, you can hear the questions as they're being asked.
Right.
And then when you actually get called in here, the attorneys can say, okay, did you hear the questions that we asked? And we can maybe speed that up. I totally agree with that. That slowed us down. And I also will do better on gauging how many people to bring in the first day. I apologize that you all had to waste yesterday. That was on me. Okay. Any other issues or questions? All right. And Ms. Gifford, when we finish here, if you'll hang out, I'll talk to you. Okay. But for right now, I'm going to have you just step out with the jurors. Thank you all very much for your service. It's been a long day and I hope you have a great evening. Call back Monday for Tuesday, because I don't think we have a call Monday.
Call back when? Monday?
Monday for Tuesday.
Okay.
Here's one too. And one of the young ladies had her notebook. We need to make sure we didn't. Miss Wallace, I think, had her notebook when she came
Does
in.
anybody going out there, do they have their notebook?
Make sure they give that back. All right. Mr. Woods, I was going to say if you'll stand, but you're already standing. Mr. Woods, in count one of case 7-2-141, a jury of your peers having found you guilty of perjury It's a judgment court, you are guilty. A fine was levied in the amount of $40 by the jury. In count 2, a jury of your peers having found you guilty of perjury, it's judgment court, you are guilty. A fine of $40 was levied, and that will be assessed. We'll set this for alternative sentencing hearing. I'm not telling you. I want to try to do this within the 45 days. Mr. McMurray, are you going to be here October 1st or the 8th?
I will be gone on both of those dates, Judge.
All right. Then I have to ask, does he waive the 45 days? And we could do it on the 15th or the 16th.
15th would be fine.
October 15 for alternative sentencing hearing. Mr. Woods, I need tomorrow for you to go to the probation office, and we need to do a pre-sentence report. Just tell them that's what we need to do, and I'll also have my assistant contact them tomorrow to let them know you're coming. All right? And if you could be there before 10 o'clock, that would be good. And they're right across the street, right next to the Hardys is where the probation office is. October 15th at 9 o'clock.
All right. Thank you, Judge.
Thank you. And now we can get Miss Gifford in. I can talk to her. I'll make this exhibit B. That way it doesn't get confused with the other one. Friday on. All right, that concludes this trial. We'll be in recess until tomorrow at 9 a.m.